Web stream audio check, 1, 2.
I can hear you.
Web stream audio check, 1, 2. Yeah, thanks. I was just checking the audio, the web stream downstream, so it sounds like it works.
I thought that might be the case.
Yeah, okay. You may notice, Kayla, I tend to talk to myself a lot, so others don't want to talk to me, so I have to talk to myself.
I understand. Sometimes you just need expert advice.
Will Ameren be here in person, or will they also be online? You think everybody's going to be online?
I would assume on wasn't sure.
Okay. Sorry?
I was just saying I'll need to turn on the mic, right?
Yeah, just push a button, and it'll show green when it's on,
Right.
and you'll hear it over that speaker too. You'll know pretty straight away when you. And the best thing is probably 3 to 4 inches is optimal. You don't have to eat it, but if you lean back, it'll be a little bit. That's just a little micro up to you. Now, shouldn't there be a court reporter online? Okay.
Kayla, were you able to reach the complainants?
I do believe she's talked to him today because she was asking about maybe showing a video, sharing her screen.
Yeah, Kayla's actually on the phone with Miss Canada right now, and she's trying to get logged in.
I can get logged in, so I'm not confident. Oh, really? I'm sorry? You know what? I've seen it both ways. I think I'm seeing it less these days. Yeah. About to put a percentage on it than I did earlier. I think it's all up to you. Another thing I noticed it's personal is the swearing in. People kind of have their own way of doing it, you know. Truth, the whole truth, nothing but the truth. So,
Yeah, fine. Watched a few good men.
What's that?
I said I watched a few good men.
So as I said earlier, I'll just remind you, that is the website, or the web X, excuse me, up there, so you can see some link in here. Is that the court reporter, Jill?
Yes, it is.
Hi, Jill, good morning.
Good morning. How are you?
Good. So, we can hear you, and it sounds like you can hear us, so everything is
Yes.
good. If there's a time where, you know, you don't hear something, you know, you can always ask the judge to have him repeat and, to make sure we got it for the record.
Perfect. Sounds great.
Thank you.
Thank you.
Mitchell. Good morning, Commissioner. And I hope you can hear me. I didn't hear any response, but anyway, this is audio from the commission hearing room.
Oh, good morning. This is John Mitchell. Just
Okay, great. Just, we can hear you fine, and just want to check in and make sure everybody can be heard. So, yeah, otherwise you can remain muted, and if you want to ask the judge or anybody anything, feel free to ask the judge. So, thank you.
thank you.
Jill, could you go ahead and mute your mic? Sometimes we do get feedback if your mic is open
Yep.
from typing and page shifting. So, but like I say, if you need something later, just unmute and ask the judge. Thank you.
Okay. Sounds good. Thank you.
Well, that's why we make the recordings. I don't remember.
Aquila, can you hear me? You'll probably have to unmute yourself.
Yes.
Thank you, Commissioner Mitchell. I'm trying to get Aquila to be able to do some testing.
Can you
Aquila,
hear me?
yes, I can.
Okay. No, that's just my phone. We're going through your phone.
That's
Okay.
a code from the come to my phone.
Okay.
And I want to let everyone know we're currently off the record. This is all before the hearing. I'm going to allow Aquila to do a little bit of testing with her screen to see if she can screen share. So Aquila, are you able to see on your WebEx where it says share down at the bottom?
Actually, I'm gonna give the phone to someone to see if they can help me figure it out. You know, I'm legally
Okay.
blind.
All right. What do you want me to do now?
If you have the WebEx open,
Yes.
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 Okay. Hello and good morning. Today is May 21st, 2024, and the current time is 9:02 a.m. The commission has set this time for an evidentiary hearing in the case captioned as Dranel Clark and Aquilla, Canada, Complainants versus Union Electric Company, doing business as Ameren, Missouri, Respondent. And that is case number EC 2024-0111. As I said, my name is Riley Fewell, and I'm the regulatory law judge presiding over this hearing. We also have Chair Kayla Hahn, Commissioners Holzman and Jason Holzman, and Commissioner John Mitchell online as well, appearing by WebEx. Will counsel for the parties enter their appearance for the record on behalf of Ameren, Missouri?
Good morning. This is Jennifer Hernandez appearing on behalf of Ameren, Missouri. Our address is 1901 Choteau Avenue, St. Louis, Missouri 63103.
Thank you. The commission staff.
Yes, thank you, Judge. This is Travis Pringle appearing on behalf of the staff. Contact information is 200 Madison Street, P.O. Box 360, Jefferson City, Missouri 65102.
Okay. In the Office of Public Counsel. I don't think they would be here today. And Dranel Clark and Aquila, Canada. Are you both there?
Yes, we are.
Okay. And you do not have counsel?
No, sir. We are representing ourselves.
Okay. Thank you.
Rosa.
And I would ask that the parties mute yourselves when not speaking in silence or turn off your cell phones to minimize distractions. That's perfectly fine that the complainants, Mr. Clark and Ms. Canada, are representing themselves. I can assist you when and where I can. There may be some questions that I can try to explain or rephrase for you, but I cannot help you to present your case. Each party can start off making an opening statement. It's an opportunity for you to give a summary to the commissioners and me of what you expect the hearing evidence to be and why that evidence will support your complaint. That does not mean you will present your evidence there. That'll be later, but you can't explain where you're coming from with your complaint. To elaborate, that's not sworn testimony or considered under oath, and so you're not subject to cross-examination where the other parties can question you about what you've stated. The commission is also not making its decision only from what's stated during the opening statements. You'll present your case shortly thereafter and can present your evidence at that time. As the complainants, you have the burden of proof, and so you will present your evidence first. You may call witnesses to testify, including yourself, offer documents and other items to be admitted into evidence. Counsel for the other parties may object to the admission of your documents or your witness's testimony, and if that occurs, you will be given the opportunity to respond to those objections. I will then make a ruling on whether the witness testimony or document will be admitted into the evidence. After you have finished questioning your witnesses, the other parties will be allowed to cross-examine them. The order that I was sent is that you will go first, then staff will cross-examine your witnesses, then Ameren. When Ameren begins, staff will cross-examine its witness, and then you will. And lastly, staff's witness will be cross-examined by Ameren and then you. In addition to questioning by the parties, the commissioners and I are allowed to ask questions of all witnesses as well. Once you have presented your evidence, the other parties will be given the opportunity to present their own. They also may call witnesses to testify, offer evidence, and make their witnesses available for cross-examination. Please try to refrain from interrupting or speaking over others who are asking questions or responding to a question, including your own questions or witnesses, unless you are making an objection. During questioning of a witness, you must ask a question and not make statements. It may seem simple. At times it can be a little difficult. So just make sure that you're asking questions and not testifying when you are questioning witnesses. And to that, I won't have you guys question each other. It'll be more of a narrative, so you will just kind of speak on what issues occurred. I won't have you guys question each other. Do we have any preliminary matters to address? I know I talked about the exhibit list. I know Mr. Pringle shared one that seemed to cover everyone's. It had at least bullet points for the complainants. I know that they had a more exhaustive list. I think they intended to maybe enter. But is that accurate what was filed by Mr. Pringle?
Yes, it is.
Mr. Hernandez, was that accurate what was filed in the position statement earlier this month?
On behalf of Ameren, yes. I do have a question about whether we'll be able to see the complainants exhibits.
We are trying to make sure that you all are able to see the information.
The information we already submitted to them.
But the information that we're trying to use for exhibits, we have submitted to Kayla. Again, just a moment ago, we were trying to make sure that did go through.
It might take a minute because it's too many of them.
Yeah, there is so much information that we're just trying to make sure that everything did go through this time. But we do plan to be sharing.
Okay, and I believe, yeah, that my paralegal Kayla has them, so, Kayla, would you be able to share those with the others? I can get you their emails, or it should be on EFIS.
I have not yet received them.
Okay.
Yeah.
And it's steady saying it's downloading, it's so many of them.
Yeah, on our end, Kayla, or I'm sorry, on our end, it's stating that it's still downloading the information that we sent.
But it's been sent.
So we're just.
And because these are late filed, I can give time to object to those later, Ms. Hernandez, if that's acceptable.
Okay.
I mean, I suppose we can play it by ear, but I'd like to be able to see what they're presenting before we go through, or they present a lot of evidence on a document that may lack foundation or be hearsay.
And I know some of them were similar, but in the position statement that was sent, it seemed like some of the exhibits may be similar between the parties, so.
Yes, and we were just wondering about that, the information that we had already sent in, if that was available.
We received some emails and a bill that were filed in April.
No, we submitted.
That was April. Because everything was due by the 22nd. We got everything in,
He
but
just said a bill. It's
yeah,
bills.
there was several, and that's been the biggest issue. It's just been
wordplay.
everything
Sure.
into you all. That's been the biggest
It's
issue.
multiple bills.
Well,
It's
we
bills
do
that's
have-
from the very first time we ever opened up our account.
We do
Okay.
have several that we have to share with you right now on this screen.
And if that's the case, we should have got warnings that y'all didn't receive them all. So I feel like this all we've been tricked down.
Okay, well, we can consider those late filed exhibits, and
Okay.
I can, again, give a deadline for them to be filed in EFIS, and then I can give another deadline for objections. And to Mr. Hernandez's point, we can play that by ear as the hearing proceeds.
Okay.
My order of witnesses, I have Ms. Canada to appear first, then Mr. Clark, then Ms. Kirschmeyer for Ameren, Missouri, and then Ms. Fontaine for the staff of the commission. And I did get an email yesterday from Mr. Pringle that there may be another witness.
Yeah.
And that was getting into some of these details regarding your bills, shut-off notices, and other things. You are the holder of that information, Mr. Clark and Ms. Canada, so I would like to, as much as possible, try to keep phone numbers and addresses out of this. I think we can refer to the addresses in question as the Spruce address and Waldorf address. I think that's already how it's been covered generally, and that would be sufficient. We can also call them the first and second properties, but it may be a little more confusing. Do you have any objection to discussing amounts that would be billed and information relating to the notices and disconnections?
No.
Okay.
And it's fine with us if you all would rather us do it the first property and the second. We can state it that way. That's fine.
I think we'll just stick to the Spruce and Waldorf. It's a little easier, I think.
Okay, that sounds good to me.
And if we're getting into any information that you believe ought to be handled in camera, please let me know. That goes for any of the parties as to anything that you talk about. I know that Ameren had filed many things that they deemed confidential, so we will need to go likely in camera for going over some of those. Just Just go over briefly what the scope of commission complaints are so everybody knows. According to Section 386, 390 of the Revised Statutes of Missouri, a complaint involves any alleged violation of any provision of law subject to the commission's authority, any rule promulgated by the commission of any utility, tariff, or of any order or decision of the commission. So those are the things over which the commission would have jurisdiction in this case. And the commission does not have the authority to grant monetary damages in the amount of actual monies. I believe that the most that the commission would be able to do is order a sort of billing credit if that was directly causative and quantitative. We can move forward now with opening statements if the complainants would like to do so.
Okay. We appreciate the commission's time. I do want to begin by saying that it's very much appreciative. The purpose of us gathering with you all today is just to review the accounts as they currently stand. Our position is that there have been several bills that have required duplicate payments, duplicate due dates, or there would be several months that we have had two different due dates with two different amounts or overlapping cycles within that same cycle. So the first question that we had is if that's the time to go ahead, or if this is just our opening statement. That's what we were trying to make mention of, and also the cold weather rule not being informed to us by the representatives of any time. And that's the biggest parts that we want to touch base with today. And the amount that was in dispute was the amount that was filed at the time of the formal complaint. But we feel that we've been taken advantage of as disabled people and several times manipulated with this situation. So that's our opening statement.
Okay. Ameren?
Good morning. May it please the commission. The commission has 4 issues before it this morning to decide. Those were listed in the list of issues, witnesses, and exhibits and position statements that was filed earlier this month. And the 4 issues are: did Ameren, Missouri err in billing complainants and or reflecting payments made on the account from September 21st, 2021 through October 2023? The second issue is, did Ameren place complainants on the correct rate plan for billing from September 2021 through October 2023? The third issue is, did Ameren violate the cold weather rule in the provision of electric service to complainants? And the fourth issue is, did Ameren fail to inform or allow complainants to sign up for the medical hardship program?
And staff.
Sorry.
Go ahead.
I was just turning pages, so I apologize for the short delay, but I have a little bit more in the opening. It's Ameren, Missouri's position that it has not violated any statutes, rules, or commission-approved tariffs in the provision of electric service to complainants. Ameren correctly billed the complainants for usage and correctly credited payments made by the complainants to their account. From September 1st, 2021 through June 30th, 2023, complainants resided at the Spruce address. On June 26th, 2023, service at the Waldorf address was started in the name of complainant Dranel Clark. On July 7th, 2023, a final bill for the Spruce address was sent in the amount of $180.53, due on July 28th, 2023. And then on July 11th, 2023, a payment was received for $108.82, which left a remaining balance in the amount of $71.71 for the final bill on the Spruce property. That remaining balance of $71.71 was transferred to the new Waldorf account on July 13th, 2023, in accordance with Ameren, Missouri's commission-approved electric tariff. On July 26, 2023, a bill was sent to the Waldorf account to complainants in the amount of $229.59 due August 17, 2023, which included the current billing charges for usage at the Waldorf address and the $71.71 outstanding balance transferred from the Spruce account. On August 15, 2023, a payment posted to complainant's account in the amount of $75, leaving a balance of $154.59. The balance of $154.59 was forwarded to the next monthly bill, issued August 25, 2023, with current charges of $235.23 and a late fee of $1.67 for a total bill of $391.49. On September 8, 2023, a payment posted to the complainant's account in the amount of $80, leaving a balance of $311.49, which is the amount the complainant state is at issue in this complaint. In regard to Ameren billing the complainants for usage under the correct rate plan, complainants began service at the Spruce address again on September 1st, 2021. And in case number ER 2019-0335, the commission approved a stipulation and agreement in that case that required new customers with AMI meters to default to the daytime overnight rate plan beginning on January 1st, 2021. And then in case number EE 2021-0103, Ameren requested a variance for the default date to be moved to June 1st, 2021. The commission granted the variance request, and since the complainants had an AMI meter as a new customer starting service on June 1st, 2021, they were defaulted per commission order to the daytime overnight rate plan, which was later renamed the evening morning savers rate. Complainants called in to Ameren, Missouri on August 25th, 2023, and requested their rate be changed to the anytime users rate, and Ameren, Missouri changed their rate as requested, and the change was reflected on the complainant's next billing cycle. In regard to the allegation of cold weather rule violations, the record will reflect that the complainants were subject to disconnection when they filed their informal complaint and subject to disconnection when they filed their formal complaint. Complainants allege that the elderly disabled cannot be disconnected from service under the cold weather rule. That is not correct. Further, the disconnections complainants that are subject to this complaint are not within the cold weather rule, period. In regard to whether Ameren, Missouri failed to inform or failed to allow complainants to register for the medical equipment registry, complainants were mailed medical equipment registry paperwork in 2022, which was never completed or returned to Ameren, Missouri. Medical equipment registry paperwork was emailed on September 5th, 2023, and emailed again to the complainants on October 25th, 2023. And to date, Ameren, Missouri has not received completed medical equipment registry paperwork back from the complainants. So that is our summary of the issues before the commission and our positions on those issues. Thank you.
Thank you, Mr. Hernandez. Staff of the commission.
Thank you, Judge. My name is Travis Pringle, and I represent the staff of the Missouri Public Service Commission in today's proceedings. On September 28, 2024, the complainants in this case, Mr. Dranel J. Clark and Ms. Aquilla Canada, filed a complaint against Ameren, Missouri, alleging a number of violations that were summarized by Ameren's counsel. Those included allegations of errors in billing, duplicate bills, allegations of putting the complainants on a rate plan they did not request, allegations that Ameren, Missouri violated the cold weather rule, and allegations of Ameren, Missouri failing to inform complainants of a medical hardship program or the medical equipment registry. In complaint cases, staff typically conducts an investigation and files an investigative report with the commission and all parties to the complaint. In this matter, staff completed its investigation and filed its report on December 20th, 2023. At the time, staff initially concluded that Ameren, Missouri had not violated any applicable statutes, commission rules, or commission-approved company tariffs that were associated with this complaint. On April 19th, 2024, staff issued a number of follow-up data requests to Ameren, with responses due on May 9th, 2024. Ameren provided these responses to these DRs late yesterday on May 20th. As noted in staff's report on page 4, staff's investigation regarding violations of the cold weather rule when the complainants were disconnected on March 4th, 2022, initially found no violation. This was based on account notes provided by Ameren in response to staff DR number 1. However, the response provided yesterday to staff's follow-up data request, DR 13, indicates that Ameren violated the stipulation and agreement reached in case number EE 2019-0382. That stipulation included an enhanced disconnection notice communication schedule. Except for customers on the medical equipment registry, Ameren is to provide notices of disconnection utilizing the timing and communication means as follows. 10 days before disconnection, a written notice is to be provided to the customer via U.S. mail. 2 to 9 days before disconnection, a notice is to be provided by text and or email alert, and 2 separate outbound automated call attempts are to be made to the customer. And 24 hours before disconnection, a 3rd automated outbound call attempt to the customer must be made. Based on the information provided by Ameren in response to staff DR 13 yesterday, it appears that the 2nd outbound automated call attempt, that is to be made 2 to 9 days prior to disconnection per the stipulation in EE 2019-0382, was not made due to a system error. Staff has been unable to do any follow-up on that DR, but we'll be making a correction to his staff report when staff witness Sarah Fontaine takes a stand later today. However, besides that violation recently discovered, staff's investigation did discover areas where Ameren could improve its procedures regarding this type of complaint. Based on the recorded phone call between Ameren, Missouri and the complainants, staff recommends that Ameren examine its current procedures and look for ways to be more proactive in guiding customers to register under the cold weather rule as an elderly, disabled, low-income customer. If a customer is providing flags or indicators through communications with Ameren employees that they may be eligible for programs, Ameren should provide the customer with information on all possible programs they may qualify for. Thank you for your time, and I can take any questions you may have.
Any questions of the commission?
Thank you. I appreciate that statement, sir. We were actually just looking over our information in reference to that March 4th disconnect. We did not have any warning on, and we were told later by, I believe her name was Terry at Ameren, that that was error.
Ms. Canada,
on the company's
right,
part.
we haven't
Our
gotten
question
into.
is, could you repeat that? Could you repeat your findings on that March 4th disconnect? Could you say that one more time, please? We could hear it.
Judge, would you like for me to repeat any portion of my opening statement?
I think we can cover it when we do evidence.
All right.
Okay.
Okay. I think we can. I heard no questions. I think we can move into the evidence portion. Ms. Kennedy, I believe you were the first witness. At this time, you would be able to present your evidence and testify, and your other witnesses testify. Can you raise your right hand
Yes, sir.
so I can swear you in?
Yes.
Do you solemnly swear or affirm that the testimony you give in this hearing will be the truth?
Yes.
Okay, you may proceed.
Okay. So I would like to begin with a question, overall question that Mr. Clark has. Would you like to ask your question? Okay, we received a phone call yesterday in reference to settling this and wiping the slate.
Your Honor, I'm going to object. I'm going to object based on privileged settlement, communications, and hearsay.
All right, this is the reason for our question. Go on, say what you got to say.
The question was there.
Hold on. There was an objection. I need to rule on it.
I'm sorry.
But then, all right, well, reset. I said.
Well, he has to roll in their objection.
And please don't speak over each other. It's a little difficult to know, for the court reporter to know, especially since we're appearing by WebEx, who's saying what. I'm going to sustain the objection, and I also want to address that Commissioner Maida Coleman, I think, joined us at some point this morning as well, so she's also present. If you want to rephrase your question, you can do that. You can proceed, but that, I did sustain that.
Okay, thank you. The question was there any, what do we want to say, cahoots or any,
Is it any one of y'all is on the payroll with
Hold
Ameren
on,
UE?
hold on. Mr. Clark, you're not testifying. It's only
the question
Ms.
was,
Candid.
is anyone on the payroll with Ameren UE at this time?
You're testifying. You're not asking questions. You can ask questions of Ameren's witness whenever they present their testimony.
That's for all
Oh,
around. That's
okay,
all around.
okay, I
But go ahead and
apologize.
question.
Well,
See how they playing. Go on,
well,
ask
my
questions.
testimony at this time is in reference to the 4 points that was brought out in the list of evidence filing. Number one, in regards to the bills that were sent to us, we moved in our home at Waldorf on June 30th is when we stopped service at the Spruce address. We have billing coming in August. Our first bill was $154 as a disconnect. We did not receive any other bill prior to that. On August 1st, I called Ameren to ask what our bill was. At that time, I was informed by the representative that no meter had.
Objection, hearsay.
Hearsay. I like
Hold
how
on.
y'all playing. Yeah,
Mr. Clark, you're not testifying.
I like how they play. Go ahead. Finish your play.
May I continue?
Hold on. I need a rule on the objection. I'm going to sustain that as well.
Okay.
That's what I'm having.
Okay, again, at that time, I sent in a payment of $75 because I did not have an amount known to me. But again, when I did receive the first bill, I was told that $75 was applied to the
Objection, hearsay.
Spruce.
I'm going to
We
sustain that.
have recordings.
Hold
We have
on, Ms. Canada. I'm sustaining that objection.
Thank you.
All right. You got food, please. Start out saying you got food.
Am I okay to go forward?
Yes, you are. If anyone else in the room can remain quiet while you testify, though, only you are presenting testimony at this time.
Okay, thank you. Again, as I was saying, I do have proof of this that I was sending in, but the reason, again, that I sent in the $75 is because I did not know what the bill amount was at that time. Upon doing so, I was informed that this was to be applied, and the paperwork shows that it was applied towards the Spruce address. However, that payment was not needed for that address because it was paid in full via the online Ameren website. The date showing that they received that payment of $108.82 was July the 11th when they received it, but yet we were billed through July 6th. Again, service ended at the Spruce residence on June 30th. So there was no reason for the bill to go through the 6th. In their own paperwork on that online statement, it shows a zero balance, paid in full, last payment $108.82. That is one of the documents that I was trying to send over to you all for Kayla to distribute. It is still, according to our phone, downloading the information. So I do apologize for that. But at that point, when we received this disconnection bill as our first bill, I was I was taken back by that. I mean, where did this come from, and how is it that your first bill at a new residence is a disconnection bill? So at that point, I did reach out to Ameren to find out what was going on. This is what led up to us filing the informal complaint, and this is the second time that we have filed the informal complaint. There was one filed in 2023 as well that we did not take on to the formal complaint level because we were instructed via Ameren to try to get a
Objection, hearsay.
I'm gonna let
If
that
that-
in.
Thank you. Thank you. Again, so therefore, we decided to go forward with the formal complaint this time because there was no bills given before that disconnection bill. And then when we looked at, and when we looked it up, we have noticed that the activity statements that we have been presented with, they are not showing any of our credited amounts as well. They were listed on the bills as additional charges. Also, in reflecting over the bills, we did notice that one in particular, the one that I'm speaking of, in fact, that they're saying was the last bill from the Spruce address. It says on there a deposit amount of $18.33. That was our credited amount, and that's why the bill went down. But that bill was paid in full in July, according to their records when they received it. I have third-party verification of everything that I'm stating because I pay my Ameren bill with my Medicare allowance. I have been doing so since January of 2023. Again, this is all information that is downloading at this time for you all to be able to view. But you all should already have that information from the from the informal level somewhere in your files. But in reference to the cold weather rule, we were not subject for disconnect at that time. And if we were, no notice was given. We have been paying our bill, if not down to zero, we've been paying it past the 50% level that we were informed by Ameren that we had to pay.
Objection, hearsay.
We found,
Hold on. I'm overruled.
thank you. We found out about the cold weather rule when I was speaking with the commission. I was informed about it. Ms. Fontaine actually was the first person that I had actually heard anything about the cold weather rule from. And that's when I moved forward on asking Ameren why we were not informed about it. Also, in reference to medical forms, we have sent off any medical form that Ameren has sent to us. Our doctor has not responded to any of them, and we have no control over that, but we have moved forward and we have informed Ameren for the need of the medical form for the CPAP that Dranel uses. So we're just trying to make sure that there is an understanding, and I am trying to make sure that there is an understanding that these bills that are accumulated between June and August, and I'm not understanding how they can accumulate that much to be that high. As I clearly stated already, on August 1st, there was no amount given to us. But now there's documents stating that this was done on the 28th or the 26th of July, and this is not so. None of the transactions or the activity statements even make mention of our credited amounts. The payments that show on the activity statements, the dates are not colliding with, or are not aligning, with the dates that I have as completed payments through the insurance company. So I am concerned that the documentation that is being used or presented by Ameren at this time is not the same documentation that Ameren has supplied us. We receive email, text, and paper statements from them in reference to our bills. So again, if we're not receiving this documentation, if there's no, after reviewing or doing an investigation, there's no documentation of it. It just doesn't make sense to me that how here it is, May of 2024, and this documentation now is presented. It's not making sense to me. There is a lot of confusion on that. But again, we have sent over all of the information, and we're hoping that before we wrap up today, you all do have the ability to see it. We do have a flash drive with some recordings on it that, if the court would allow, we would play, so that it's not considered hearsay, the statements that I'm making at this time. Besides that, I don't feel that there's anything else that I want to bring up at this time. But Mr. Clark does want to speak on his testimony as well. I do have a question that if I do think of anything else after he's testified, will that be done at cross-examination, or would I be able to interject at any time?
You can recall yourself. I'm comfortable with that, at least while you're presenting your evidence. If it, between Mr. Clark and Mr. Olivastro, if you have questions or more evidence to present at that time, you can recall yourself.
Okay.
Okay.
All right.
And so, but go ahead. Are you finished, or?
Well, you said that would be for the evidence portion, so I think I am finished at this point.
Okay. Cross by staff.
No cross-examination, Judge. Thank you.
Thank you. Cross by Ameren.
No questions, thank you.
Are there any questions from the commission? Hearing none, I have a few questions. I'll try to keep it brief. Referring to your complaint, you had listed a statute 536010 regarding affected small minority business. Do you have a home business?
Yes, sir. Yes, sir, we do.
What is that business?
It is called the EIT Enjoy It Together LLC.
Okay.
And we are in good standings with the state.
Sure. Thank you. And you had mentioned that you received email, text, and paper, meaning mail, I believe, statements for your bills.
Yes, we originally asked for paper and email communications, but we did not receive the paper ones at the Spruce location at all. We only received the email communications, and then we were able to go online to view our bill at that location. However, at the Waldorf location, we have not the ability at all to see anything online in regards to this this bill and this address, and the Spruce address has been closed. We do not have access to that either, to review that online communication anymore. We do have screenshots from when we did though.
And is the online, is that through a portal, or is it just an email that has that bill?
That is through the Ameren website. When I refer to online, I apologize. I am referring to the online access for customers via Ameren's website.
And you need to log in for that?
Yes, you do have to log in for that, but we cannot log in. When we log in with this at the Waldorf address, there's nothing being shown. There's no access to it, it will not allow it. When we log on for the Spruce information, it says that this account has been closed, and then it's just blurry behind that on the screens. But we do have the screenshots rendered from that that says zero balance, last payment being 108.82,
Okay, and.
July 11th.
And you said that you paid the $75 yourself on, I'm not sure what day that was.
On August, when I called in August 1st, I made a payment initiated on August the 2nd for $75 that was applied to the Spruce address as a last payment on that account when that account had already been paid in full with the 108.82.
Okay.
Off my, and that's, I'm sorry, let me clarify, that was done off of my medical allowance. All of my payments are done through that.
Sure. And then you, when did you move out of the Spruce address? What day?
We moved out of the Spruce address officially, I believe, on the 30th of June is when we stopped the service. We signed the papers closing on June 27th. And I'm glad that you did bring that up, actually, because we were disconnected on the 24th of June and had to be reconnected to the 30th as a mistake. For what we had set up, the closing date had gotten moved, so we ended up ending service on the 30th. We did not go into the month of July at all.
Okay. That was all of my questions. Is there any recross?
None from staff, Judge. Thank you.
No, thank you, Judge.
Okay. We can move to Mr. Clark. Will you raise your right hand?
It's right.
Okay. Do you solemnly swear or affirm that the testimony you give in this hearing will be the truth?
The whole truth.
All right.
Yes.
You may proceed.
My question is, what my testimony is that I'm trying to figure out, I mean, last time I checked is you pay your bill once a month. I'm pretty sure we are supposed to once a month. As we having so many bill cycles and different amounts for the same month and threaten to be, if we don't send it, we get disconnected after already receiving a payment, first off. Second off, why is every 3.5 months after receiving payments from us, it equal up to the same amount of money that you saying that we owe that y'all want as a lump sum based off our own payments? It's simple mathematics. If 1 + 1 is 2, you can't tell me 1 + 1 is 11, man. If 11 + 11 is 22, you can't tell me it's 4. It's simple mathematics. How can we have all these payments that's due from a location that we weren't even in less than 30 days? And you already sent us bill for August, September, and we're in the month of July. It's impossible. It's impossible, man. It's simple math. It's common sense, man. I'm not here to play on nobody's intelligence, and I please hope ain't nobody here to play on mine, man. Right is wrong is wrong. And why all our village usage is matching the same exact thing from the last 3 years? From the previous address. It all matching up the same. And we had a whole new location, residence. The bill amount is the same amount of bill amount that it was the year before that, and the year before that. The same exact amount. Saying that we owe this amount, 311, then it go to 4 something, then it go to 5 something, then by October, it'll be 6 something. repeated. That's insanity. That's insanity, man. That's a mental problem now. Peak time at that. Ain't no way that a person that be in a location less than 30 days have a bill that's more than $200 and some dollars. Every 12 days you receive a payment from us. Every 12 days. We got proof there's a document that y'all receive payments from us at least 2 or 3 times a month, man. If you pay your bill down to 0 and supposed to have credit, how the next bill is over $300 some dollars? Or the credits is not even showing at all. I never asked to use my credits or apply my credits to anything. Not one time. Now I can't even track my credits down. I asked where my credit's at, I don't have none. What? That's stealing. That's stealing, and that's misusing government funds. You stealing from an insurance company and all to say to us that we don't have credit or you didn't receive this payment, but we got confirmation from Ameren saying payment is received. Credit amount is this, but nowhere on that receipt saying this amount is for this for this cycle right here. Now on your activity sheets, you got these payments, but you don't got it next to anything. It's just blank. This amount blank. What it's applied to? You just taking our money and just doing anything you want with it. And then putting out credit for additional credit, which, by the way, we all know, and I'm speaking for Ameren too, if you could object or whatever you want. We all know all of this is on false readings. It's all false readings. From the very first time y'all disconnected us wrongfully, y'all didn't try to make it right since then. So every payment from that time on is false readings. Based off our own money. We paid every month, sometime more than twice or more than once. It's impossible to say that we got a disconnection bill from a new resident that we weren't even in there for 13 days yet. It's impossible. And then try to say our AC bring the bill up to 127 when we ain't even have AC. We had to get it fixed, which we got proof of that too. So if you sworn to tell the truth and the whole truth, tell it. Tell it, man. Because y'all the reason I'm on a CPAP machine. Ameren is. This ain't hearsay. This is facts. Y'all sending y'all little evidence looking like a cat in head and eyes looking like a Stephen King novel. Come on, man. Our evidence is Ameren evidence. They telling on themselves. If y'all allow these people to manipulate y'all too, I'm going to the news. Flat out, man. They bullies. They monopolize us, man. Y'all the reason why people out here committing crimes, man. Ain't no way a utility bill should be more than somebody's rent or mortgage. Come on, man. It's insanity, man. And y'all won't even admit that y'all wrong or make it right, man. That y'all force a person to go through all of this, man. And then call us and talk about, we'll wipe it. Come on, now. Have some type of destiny and heart, man. We all human beings here, bruh. Wrong is wrong. If we feel like this was right, we won't be going through this right now. If I don't seek justice now, I'm gonna seek justice, bruh. You told me to do what I gotta do, and I'm doing that, Ameren. Them the words out your mouth. Do what you gotta do then. Okay.
Objection, hearsay.
They ain't heard say them are facts, man. I
Hold on,
sworn
Mr.
to my
Clark.
higher power. Don't do that. I don't play with my higher power. Don't do that. Them facts.
I'm going to sustain that objection.
Them facts. I'm not here to play on nobody's intelligence, man, or monopolize nobody, man. That's not the reason we here. We here because we speaking on for those that can't speak for themselves, man. It's bigger than us. It's bigger than us. Y'all the only ones that we can get electricity from, and y'all feel like y'all can do what y'all want to do, man. Any objection to that? That's what I thought. That's what I thought. I want to use y'all own evidence. I'm going to contradict y'all own evidence. I don't even want to use mine. I want to use y'all's. That's what I want to do. Bring that falsified activity sheet into the play. I'm done. I want to use theirs.
He's completed his statement.
I want to use theirs. Let's play ball. Let's play. Ding, ding, ding. Over the field. Let's play.
He said he's finished, sir. I'm sorry, he's very upset about this.
That's okay. He will need to appear for cross-examination, though.
You do have to sit down for cross here.
It's how they heard. We don't got AC on right now. I had to get something to drink.
Here we go. Okay, they're ready.
Is he ready?
Yeah, I'm here.
Okay. Thank you, sir. Cross by staff.
Yeah, thank you, Judge. Very brief. Mr. Clark, you mentioned fake readings. Do you recall that?
Yes.
And are you referring to the readings from your electric meter?
It wasn't never no reads from the electric meter, sir. That's why I said false reading.
Have you ever requested for the company to test your meter?
Yes. I asked them when we first came to this new location at 9240.
Just
Waldorf. Sorry about that.
Hey, no problem, Mr. Clark. And when you requested that meter test, did that meter test occur?
No, they said they could do it from where they at.
Did they, I guess, is it your understanding you have what is referred to as a smart meter or also advanced metering infrastructure, AMI?
Well, me personally, I don't know nothing about that. I don't know if it's smart or nothing. I just asked for it, and they said they could do it from where they at.
And did they tell you what the results of that test was?
No, sir.
All right. Thank you, Mr. Clark. No further questions from staff, Judge. Thank you.
Thank you, counsel. Cross by Ameren.
No, thank you.
Oh, y'all don't got no questions for me? Oh,
Mr.
man,
Clark,
come on now.
You're done testifying. Questions by the commission, from the commission. Hearing none, I have a couple as well. To kind of piggyback up off of that, has Ameren ever sent anyone to replace or change the meter at either
No, sir.
address? Okay.
No, sir. We never saw a take since the account been open in my name. Never.
Okay.
Not the old address or the new.
And you've mentioned several times that you have a CPAP machine. How have you displayed that or provided information about that to Ameren?
They sent us. They told us they was gonna send us a document to send to my doctor, and for us to mail it back. So first, it took them a while to even send us a document. It had to take us to do this complaint for them to send it to us. And then once I sent it out to my doctor, at this time, we've been going through this stuff since COVID and all of that. So, it's hard to get into a doctor. You got to make an appointment and get in, So it's like out of reach on that. But I have the CPAP machine right here if y'all want to look at it.
Sure. I don't know that that's necessary, but What day did you receive it? You said that if you can recall.
What day was that?
I,
I know it was after the complaint.
Okay, so it was sometime in the fall 2023 or later.
Now, this form of
yeah,
complaint.
yeah, that's
Yep.
what we did.
Yeah, in 23. Sometimes 23. Yeah.
Okay. And I believe that you stated that this was through United Healthcare that your payments are made. Is that something that you have to provide to UHC, or are the bills sent directly to them? How does that process work?
But Ms. Canada had to speak on that issue right there.
Just to answer your question, they initiate a payment. I put in the information into their site, initiating the payment with United Healthcare, at which point, from what I'm understanding, they mail the payment in. The process can take up to 5 days. But in January of 24, we switched over to Aetna, and they do direct payment from the form of like a Flex card or a debit card with a MasterCard logo. That card ends in 5669. I'm sure Ameren can see that that's how the payments have been made through that.
Okay.
But we do get the notification once the payment is completed from not only Ameren, but also the insurance company, United Healthcare and Aetna.
In what form do you get that notification, the receipt?
We get them in email and in text.
Okay. I think that was all the questions I had. Is there any recross?
None from staff, Judge. Thank you.
No, thank you, Judge.
Okay. And next, I think, is Mr. Olivastro.
Okay, he's going to get him real quick.
Okay.
He is our tenant, so just give us 1 second for him to enter the room. I apologize for the delay.
It's okay.
Hello, this is the court reporter. Could I get Mr. Olivastro's name spelling, please?
Sure, I believe it's Olivastro.
Thank you.
Name is, his first name completely is Anthony. One second. Okay, come on up, Tony. All right, here he comes. Hey, Tony. Here you go.
All right. Hello.
Okay. Hello, Mr. Olivastro. Can you raise your right hand?
Yeah.
Okay.
I got it raised.
Do you solemnly swear or affirm that the testimony you give in this hearing will be the truth?
Yes.
Okay. Ms. Canada is your witness.
Correct.
Okay, Tony.
Can you speak into the mic? Sorry. May be
I'm
difficult
sorry.
with you
Let me have
sharing.
him sit down a little closer to me so you all can hear better.
Sure.
How are we on sound? Good?
We can hear you.
Okay, great. Thank you. Okay, Tony.
Okay.
This is your second time living. I'm questioning you. This is your second time living with us.
Correct.
Here at the Waldorf location and at the Spruce location, could you just describe to the judge what you have observed?
So, I moved in with them, and the prices changed on the agreement multiple times due to this Ameren bill. So, it's affected the agreement that me and Miss Canada have made.
As a landlord to tenant. Okay. And how would you say that it has affected the agreement that we have made?
The price has actually gone up compared to the agreement that we have made
Hold
multiple
on.
times.
Hold on, Mr. Alvastro.
Okay.
There was an objection.
On relevance, I'm not sure how this is relevant to their complaint.
Well, because he's a tenant of ours, we've had to increase the amount that we have asked him for in regards to utility. We have charged him a flat rate to rent the space, and then another rate for utilities if they were to fluctuate. So with that being the case, we're simply showing that this has not just affected us personally, this has affected us business-wise as well. I don't like to make it a practice of having to renegotiate the terms.
I'm
Yeah,
going to
so,
overrule the objection.
Okay, so yeah, so there's been a fixed rate that we've agreed upon, and that's fluctuated. You know, it's actually increased, you know, multiple times, and you know, from the agreement. So,
And would you say that that is a direct result of us showing you the bill and saying that it
Yeah,
was higher?
yeah, exactly. That's exactly what it is. So, you know, it kind of messes with the agreement that me and Miss Canada have had. So,
And does that affect you financially as well?
absolutely.
Okay, okay. Thank you, Mr. Alabaster. That's all I wanted you to testify on.
And this has been more than once in 1 month. So they've raised the price twice in 1 month. You know, because they've been billed more than once in 4 weeks.
So this is a recurring issue.
You know, so they raised the price in the middle of the month, and then at the end of the month, they told me they added more money to it. It's like, why would the bill keep going up? That doesn't even make sense.
Instead of
Either that or instead of going down or staying
the same.
average. You know.
There you go. Okay, that's all I have for questioning on Mr. Alabaster. You're okay. You're okay.
Okay. Is there any cross by staff?
Yeah, just one question, Judge. Mr. Olivastro, were you saying that your rent is changing every month because of the Ameren bills?
No, just the utilities.
Oh, okay. All right. Thank you very much for that clarification. No further questions.
Cross from Ameren.
No questions, thank you.
Okay. Any questions from the
She said no
commission?
questions.
Yeah, I'm glad you said that too, but
If you can please mute your mic when you're not speaking. Is there any questions from the commission? Hearing none, I did not have any questions either. We can move on, I think, to Ameren, Missouri's first witness.
Thank you.
And Judge, just before we move on to Ameren, this is Travis Pringle from staff. Just kind of wondering how we wanted to handle the complainant's evidence.
I think we'll do late filing and give time to object. I was thinking by Monday to give them the weekend if necessary to kind of try to get it filed, and then give the parties until Wednesday to object.
Excuse me, Your Honor, Monday is a holiday.
Oh,
I
you're right.
just wanted to
You're right. Sorry.
remind-
Tuesday then, and then Thursday to object.
That sounds good to me. Thank you.
Are there any objections to that?
None from staff. Thank you, Judge.
And I guess in terms, do we know what the specified exhibits from the complainants are that are going to be filed?
I listed them in the exhibit filing that was done, that Mr. Pringle submitted. Again, those are recordings, emails, receipts.
And we also have flash drives.
And we also have downloaded those recordings via flash drive. So it's all, to be honest, it's all information that we have received from you, Ameren as a company, from United Healthcare and Aetna as well.
We all disabled.
And proof of his and my disability and how it is affected by the electric.
And I can list it's in the position statement. It says bills, email communications, confirmation of payment texts and emails, complainant recordings, proof of payments from third-party insurance company, and payment initiation and completion, and then written statements from a few people. I don't know that. Are you still intending to file a written statement from Mr. Alabastro, or does his testimony cover that?
I feel like his testimony has pretty much served as his written statement, so I'm okay with that. If you all are.
Yep.
Okay.
So.
I guess, Judge, my only concern is, we can file objections to these documents, but if the commission were to admit them, we would not have an opportunity to question anyone. The documents that are admitted, we would be able to do no cross of the witness based on those documents.
And you'd be able to ask for rehearing if necessary.
Okay. I guess with that understanding, if they are admitted and to the extent we have questions, we can ask for rehearing. Well, rehearing in terms of, let me make sure I understand rehearing. Not rehearing in terms of the commission issues a final order and we ask for a rehearing of that order. You're saying that the evidence would be reopened for an additional hearing.
I think we could do that if necessary. Sure.
Okay.
Okay. It is your witness, Ms. Hernandez.
All right. Ameren, Missouri calls Aubrey Kirschmeyer. Do you have your screen on? Okay.
Okay, Ms. Kirschmeyer, can you raise your right hand? Oh, I see you're raised, sorry. Do you solemnly swear that the testimony you give today will be the truth?
I do.
Thank you. You may proceed, counsel.
All right. Ms. Kirschmeyer, can you first spell your name for the court reporter?
Sure. My first name is Aubrey, Aubrey. Last name is KRC like cat, MAR.
And Ms. Kirschmeyer, where are you employed?
I work for Ameren, Missouri.
And what is your position at Ameren, Missouri?
I am a regulatory liaison.
And as a regulatory liaison, what do your duties include?
One of my main duties is to work internally to ensure that Ameren, Missouri's business practices are in compliance with both the commission's rules as well as our own tariffs. I also serve as company witness in formal complaint hearings, assisting with all of the investigation.
All right, and are you familiar with the complaint that's been filed by Complainants?
Yes.
And did you do any investigation of the complaint?
Yes, I did.
And how did you investigate the complaint?
So anytime that I'm investigating a formal complaint, I start by doing a deep dive investigation into everything that has happened with the account. I listen to all telephone recorded calls between the customers and our employees. I review all of our account records, which are stored within several different computer programs. We use CSS is the name of one of our computer programs that store all of our account records, as well as CRM is another new program platform that we're moving to. I review all of the account activity statements, all of the billing records. Basically, I look at every single thing that has transpired between the customer and the company and all of the communication that we have shared with them in order to determine whether or not Ameren, Missouri has followed all of the correct business practices and handling of the account.
All right, and do you have Exhibit 100C in front of you?
I do.
And do you recognize these documents?
We do not have that exhibit in front of us.
It was
Is there any-
emailed at 7:44 yesterday, if you check your email.
Okay, thank you.
Go, proceed, counsel. Sorry.
All right, thank you. Sorry, and did
I think you had asked me what this Exhibit 100 is.
Yes.
I identify this as all of the billing statements, monthly billing statements that were sent to the complainants at the Spruce location as well as their current location on Waldorf through November of 2023.
And are these billing statements records that are maintained in the normal course of Ameren, Missouri's business?
Yes.
And are these billing statements true and correct copies of those business records?
Yes.
All right, with that foundation, I would offer Exhibit 100C into the record.
Are there any objections to admitting Exhibit 100C, the billing statements, into the record?
Not from staff, Judge.
I do have an objection. I am trying to get to that document at this time. I'm not sure how I feel about it until I see it.
It appears to be, it's pretty lengthy. It appears to be billing statements from probably your first bill to date.
Okay. Okay. We would like to check the accuracy of that document. So we would like to jump to that.
Okay, I'm going to overrule that objection. You may proceed, counsel.
Thank you. All right, Ms. Kirschmer, did you review all of these billing statements?
Yes.
All right. Do you remember, well, let me ask you, there was an allegation of fake readings regarding the electric meter. In your review of the account records, did the complainant ever contact Ameren, Missouri to request a meter test?
I listened to all, I think 40 plus phone calls between the complainant and the customer, or the customers and Ameren, Missouri from September of 21 to present. And there was never a request for a meter test on any of those.
Objection. Hearsay. Excuse me, but actually, when we set up service at the new address, we asked that there be someone coming out.
Ma'am, you can't testify while you're objecting. So your objection was hearsay?
Yeah.
Judge, it's not. Oh, okay. Thank you.
Yep.
All right. So you've reviewed these bills.
Yes.
And in terms of charges for electric usage, are those charges based on actual usage by the complainants at the address?
Yes, and I can actually demonstrate where you can see that on the bill if you'd like.
Certainly, go ahead.
So halfway down the front page of a bill statement, the electric service details is listed out. It shows the dates of service that are being billed. So for example, I'm just looking at the first bill statement that was page 1 of 112 with this exhibit. And so the service dates were September 1st, which is the date that the services were begun in Mr. Clark's name on Spruce, through September 11th, which was the end date of the reading bill cycle for that billing group where that location was. So for 10 days, this first bill came out, and the meter number lists the meter number, the service dates, the usage type, and then the reading type shows actual. And that means that we did obtain an actual reading for that meter. There was no fake or estimated readings for any of these. So if you actually scroll through all of these bill statements, you will see actual readings on all of them.
All right. And can you explain Ameren, Missouri's billing process in terms of how often Ameren, Missouri issues a bill to a customer?
Yes, so our billing cycles can run between 28 and 32, 33 days, depending. We do bill once a month for a location, and our bills, our accounts are set up where each premise, and a premise is the location of the meter for the service, has a specified meter bill group. So that means that, you know, all 1.2 million electric customers do not have their bill read on the same date on the 1st of the month and due on the 15th of the month. Obviously, we have to spread that out so we don't have everything due at once or all of the readings generated at the same time. So the bill group is then receives their bill approximately the same date every month with the same due date every month, but it's not necessarily the 1st or the 15th. So it's basically depends on where the service address is, what bill group that account is assigned to.
All right. If you could turn to page 85 of Exhibit 100.
I'm there.
All right. And what is this what is this bill referencing?
So this is the bill statement that was generated June 22nd of 23 for Mr. Clark's service at Spruce. And the bill generated for $108.82 with a due date of July 15th. The service, if you go to the second, page 86, the electric service detail shows that this was serviced at the Spruce address from May 13th through June 14th of 2023. It was a 32-day bill.
All right. And then page 89.
I would like
that
to
bill.
object to that, please.
What was that, Ms. Canada?
I would like to object to that, please.
On what grounds?
On the grounds that I would like to know what the relevance is as to what we're actually discussing. That she's saying that this is for service for the prior month, but that bill was due on the 14th, and that bill that she just mentioned had a amount of $95 for the month of May. The month of June, which was due by the 15th of July, the final bill we received was the $108.82. So there was no reason to even bring up the bill before that because that bill was paid.
Well, Your Honor, the complainants are alleging that they were billed more than once a month, and I'm trying to allow the witness to explain why there were two bills issued in the month of July 2023.
It was only one bill sent, ma'am.
Well, I'm going to overrule the objection. You can cross-examine Ms. Kirschmeyer,
Okay. That's fine.
and you
That's
can
fine.
address it then.
That's fine. Mm-hmm.
Proceed, counsel.
Okay, so on page 89, that bill states it has a due date of 7/28/2023. Do you see that?
Yes.
Okay. And then referencing the bill you just discussed prior, why would complainants receive two bills in 1 month in this instance?
Sure. So the bill that was generated June 22nd for the 108.82 was due July 15th. That was a regular monthly cycle bill based on the bill group that this account was under. So since they did, and I believe I believe Ms. Canada mentioned that they closed out their account on Spruce effective June 30th. So we had already sent a regular cycle bill for the month, which was due July 15th, but then we also had to close out that account and send out a final bill. So the final bill was generated July 7th, and it was for dates of service from June 14th. So we picked up from the last date of the regular billing cycle for the month, and it was through June 30th of 2023. So this was final bill.
Falsified accusation.
What was
Objection.
that objection?
That is not correct. In fact, we received the bill for the 108. Yes, that is correct. But that bill went through July 6th. It didn't generate on July 7th. The dates that you all have is the 22nd through July the 6th, not in fact the 14th. The 14th was overlapping bill cycles.
I'm still trying to manipulate.
Counsel, do you have a response?
I'm not sure what the objection is in order to respond.
Sure. I think
Our
she's.
objection is that that statement was false.
I think she's arguing the authenticity of the document, which honestly, it's already been admitted. I'm going to overrule the objection.
Okay.
Again, this is
Can I ask that it
something
be
you can cover in your cross-examination.
Okay, go ahead.
Yep.
Sorry.
Go ahead with your response, Ms. Kirschman.
So I just wanted to finish by explaining. So that there were two bills due in July. One was the regular cycle bill that was due July 15th. The final bill, which covered service for the remaining 14 days before the account was closed out on June 30th, was then due on July 28th. Now, the bill that was mailed, the second bill that was mailed that was due in July 28th, indicates on there that this is the final bill. And it also indicates that if the prior balance has been paid, that refers to the 108.82, pay the current amount of $71.71 only. So since that payment of 108.82 had not posted to the account by the time this final bill came out, it's still reflected.
Objection, we do not have that bill. When no bill sent to us, objection. That's hearsay.
We never received that bill, or else I wouldn't have called on the first and asked what the bill was.
I'm going to overrule that objection as well. Again, and that's something you can cover in your cross. Proceed, counsel. Ms. Kirschmar, you may have been testifying. I apologize.
That's okay. So I just wanted to explain that, yes, there were two bills received that were due both in July, but they did not overlap any service dates. And the final bill that was due July 28th actually would have been for just the current amount of $71.71 only. Since we did receive the payment of 108.82, it was just received after this bill was generated, which is why it wasn't reflected.
Okay. If you could turn to page 93.
Got it.
And could you explain on this bill the 7171 that is transferred from one account to the new account of complainants?
Sure. So as I just testified to, the final bill that was sent out that was due July 28th for the service on Spruce through June 30th indicates that the 7171 was the current amount due. Once again, this bill wasn't due until July 28th. But as I mentioned, each premise or account has a specified bill group, which means that that's the date that the bills are sent out. So the first bill that was sent out for the new address then on Waldorf was generated on July 27th. So it was generated even before that final bill of 7171 was due, since that wasn't due until July 28th. So we did include at that point, since the new account bill generated before the final bill balance was paid, certainly wasn't overdue at this point because it hadn't yet been due. But it is in our tariff that we can transfer final balances from one account to an active account as long as it's the same type of service, the same customer. So when the new bill was generated, the first bill on Waldorf, we went ahead and transferred that balance of 7171 from the Spruce address to the current address. So that way everything is due.
Objection. We don't have a tech to be able to verify that this information that you're sharing with us is actually accurate, because none of us have been trained to read these documents the way that you're describing them.
So are you objecting that this is improper expert testimony?
Yes, I am.
Okay. Can the court?
I guess my response.
Go ahead.
Go ahead.
Sorry.
Sorry.
No, go ahead.
My response to that is that Ms. Kirschmer has explained her employment, her activities while being employed with Ameren, Missouri, and that she reviews billing practices and bills issued to.
But that consists of hearsay.
Hold
well,
on.
it goes to.
Go ahead, Ms. Hernandez.
It goes to her knowledge of the substance to what she's testifying to, and her understanding of the billing process and the bills that are issued to customers.
But the reason, Your Honor, for our objection is that we don't have anyone on our side to be able to verify that the information that she's saying, the way it's being presented, is accurate for all of our understanding. The only person who understands what's being presented is Ms. Kirschmeyer.
I'm going to overrule the objection, but I think, again, keep in mind that you can cross-examine her whenever it's your turn to cross-examine. And you can question about the concerns you have.
That's
Okay.
fine, Your Honor.
You may proceed.
Were you finished with your response, or?
I believe so.
Okay. In all of the bills in Exhibit 100, there's an area in the top left-hand corner that states current detail for the statement, and then there's a listing for additional charges. Do you see that?
Yes.
Okay. What types of things are included in that category in terms of additional charges?
Additional charges could be things such as a overpayment of an account, so a credit that transferred over from the previous month's bill, a transferred amount. Certain late payment charges could show in that category. And if I may, I do want to point out that additional charges, the verbiage on that can include so many different things. It can be a credit or it can be a debit. And the verbiage for additional charges has actually been changed to additional adjustments, and that was changed at the end of September 2023. So I just wanted to kind of keep that in mind, because there have been times that a credit shows in the additional what used to be called the additional charges section. And even though there was a little negative in front of it that showed it was a credit, we wanted to make sure that it was clearer to our customers that this is not necessarily a charge. It could be a credit. So the words, changing the verbiage from additional charges to additional adjustments has been a way that we've been able to clarify that for our customers.
She's contradicting herself, man. You should inform your customers what they really mean ahead of time.
And our bills since September still say additional charges.
Okay. I'm going to overrule the objection. You may proceed.
If you can now go to what's been marked as Exhibit 101C.
I'm sorry, what is that? Oh, I see it, the payments. Okay, I got it. Thank you.
And do you recognize this document?
I do.
Okay, and what is this document?
This is my response that I created for response to one of the data requests in this case received from staff, data request number 5, and it was asking for the payment history for the accounts, the complainants accounts for both addresses, the address on Spruce and the address on Waldorf from January 21 to date, which was submitted November 2nd. So it was through October then.
And then the information that is provided in response, where did you gather that information from?
So I gathered this information directly from our customer accounting system, which, like I mentioned earlier, we refer to as CSS, as a listing of all of the payments, the payment dates, the dates that they were posted to the account, the amounts, and then where the payment was made or how it came into our company.
All right, and the payments to CSS, is that a normal business record that's maintained by Ameren, Missouri?
It is, yes.
And is this, your response, is that an accurate copy of the business record that is maintained by Ameren, Missouri?
It is, yes.
Okay, with that foundation, I'd like to offer Exhibit 101C into the record.
Are there any objections to admitting 101C, the account payment history?
Yes.
Yes, it is inaccurate. There are several spots on that document
Just not showing.
that are not showing correctly, and if not even in the right column. So,
It's missing payment.
and it's missing payment information as well.
What's Ameren's response?
I mean, my response would be that I'm not sure what their objection is, but it sounds like they're questioning the information, which may be more proper on cross-examination versus, I don't know what the objection is.
I'm going to overrule it.
It's not
Just for the
accurate.
record, Judge, no objection from staff.
Sure. Thank you,
It's
Mr.
not
Pringle.
All right, so 101, Judge, has been entered.
Yes, sorry.
Admitted?
101 has been
Okay.
admitted. 101C.
Thank you. All right, so if we could stay on 101C, I want to ask you, there's a column to the far left that has a date for each payment. Can you explain how Ameren comes to the date that's in each of those payments?
So this is the date that the payment actually posted to the account, which there may be times that depending on how the customer makes the payment, there's generally a delay in the timing from when the customer makes the payment until it actually posts to the account. Obviously, there's time needed for processing within our treasury and our vendor that processes our payments for us. So, for example, if a customer mails in a payment on the first of the month, it likely won't post to the account until maybe the 7th, 8th, or 9th of the month. So this is the actual date that the payment posted. It may be different from the date that the customer may have made that payment a day or two earlier. So, and for energy assistance payments, that payment could have actually been pledged by the agency a month or two in advance, but not posted to the account until we actually receive the payment and it's physically applied in the system.
So the dates that a customer maintains a payment was made may be different than the date that Ameren posts the payment to the account?
That is correct.
Okay, objection to that. Even if it's not posting to the payment, it should still be applied to it. So you're saying that it's not reflecting by the date that the person might have sent it in, but it's still applied. Even if we're not seeing it, it's still been applied.
I still think this should probably be covered in cross-examination, so I'm gonna overrule that objection.
I apologize, Judge. I'm
You're
just
okay.
speaking. Okay.
Might make note when you have questions that
Yes.
you want to ask.
I definitely am. Thank you.
You may proceed.
Thank you. If you could look at Exhibit 102C,
Yes.
and what is this document?
So these are account activity statements for both of the accounts in question here, the Spruce account as well as the current account on Waldorf. So this is the account activity statement, which is created and generated directly from our CSS customer service system. So you put in the dates of service and it generates this statement, which reflects all of the billing information related to an account, the type of transaction, the billing period, charges, payments, the total balance, previous balance, due date, the usage of the bill in question. It includes all kinds of billing information.
All right. And is this account activity statement a record that is kept in the normal business of Ameren, Missouri?
Yes.
And is this an accurate copy of the business record held by Ameren, Missouri?
Yes.
And with that, I would offer Exhibit 102C into the record.
Are there any objections to offer to admitting Exhibit 102C, the account activity log?
No objection from staff, Judge. Thank you.
We were trying to pull up the information. I'm sure you saw us trying to get to that. What are the dates that she has for that activity statement ending? That's the only thing. We have one pulled up in front of us, but we're just trying to make sure it's the same one because I can't find it in that information that she sent by that by Exhibit 108. I just wanted to know the date that it ended on, that one she's looking at.
Sure, it's 102C, the account activity statement in that email from yesterday from Ms. Hernandez. The last date is July 13th, 2023 for a transfer of a debit, and then it's a 4-page document.
Right, Judge, and I would just add on that that's the last page, page 4, then continues with their account history at the second address, the Waldorf address, through October 24th, 2023.
Correct. Sorry, I didn't notice the 4th page. So that goes down to, as Mr. Hernandez said, October 24th, 2023 on page 4.
Okay. I am looking, yes, okay. I'm not actually looking at the one that you all are. I apologize, you all. I am legally blind. I'm pulling up the one that I have, but the date, the 10/24/23 date is the same on this activity statement that we were sent and is in our evidence as well. So I'll just look at this one as she speaks on it, if that's okay.
So are you objecting or no objection?
Well, no, I'll just save it for cross if that's okay.
And you are sharing your screen right now. You may want to stop that because this is a live stream.
Let me see here. Okay, are we back to not sharing at this point?
Yep, you have
Okay.
removed it. Thank you.
Thank you. Wasn't aware. Thank you.
I believe sorry, did you say you were not objecting?
No, I'll be saving it for cross. Thank you.
Okay. And
So 102 is omitted, Judge?
Mr. Pringle, did you say no objection as well?
That's correct, Judge. No objection from staff. Thank you.
Yes, it is omitted.
Okay, thank you. So let me ask you, in terms of this account activity statement, would each of the complainants' payments received by Ameren, Missouri be recorded on this document?
Yes, they are.
Okay. And the usage from each bill is recorded on this document as well?
Yes.
No, I'm missing a payment on this form. I would have to object to this. I'm noticing that there's a payment that is missing from this document.
You'll need to address that in cross. The document has been
Okay.
admitted.
Okay, I'm sorry.
You're okay.
If you would look at Exhibit 103C, please.
Yes.
All right. And do you recognize these entries?
I do. Yes.
And what are these entries on this document?
So within our billing account system, CSS, anytime there is any type of interaction with the customer, whether it be on a phone call, through a batch process, which means that something is sent automatically through the system, any type of account interaction is captured in what we call account contacts. And these are account contacts that were generated and entered onto.
Ask her again, can you explain what this document is?
Sure. These are contacts that were left on both the Waldorf and the Spruce accounts that are related to the sending of medical equipment registry paperwork to the customers, as well as contacts that were left on the accounts related to the rate options.
And where do we?
It's our time.
No, I'm.
It would be Exhibit 103C.
Yeah, it's Exhibit 103C is what we're discussing.
Okay, I'm going to.
And are each of those account entries, are those maintained in the normal practice of Ameren, Missouri?
Yes, they are.
And are each of those account entries
We saved it.
listed in Exhibit 103C? Are those accurate copies of the account entries held by Ameren, Missouri?
Yes.
Okay, with that, I would offer Exhibit 103C into the record.
Are there any objections to 103C being admitted to the record as a contact log?
No objection from staff, Judge. Thank you.
We are still trying to locate it in this email. I'm sorry.
You're okay. It is
It
3
doesn't-
pages.
It does not let me just kind of let you know on our email, it's just strictly showing for like the word exhibit EXH, then it will show 1O and then give us the letter. So we're literally having to click every one of them to find the right one that you guys are discussing at that time. And yeah, but that is.
Bear with us.
So I'm trying to pull them up as she's mentioning them, but they've been shortened, so I can't see the entire word. I apologize for that, but
I
I'm
believe it's the 4th PDF that's been attached. I don't know if that correlates for everyone, but that's how it is for me, is it's the 4th PDF.
Okay, let's see if that worked. Yes, that did work, Your Honor. Thank you. Okay, and then just so I understand correctly, Jennifer, there from here, it would be 104, 105, after this 103, the 4th one down. Is that correct?
And 104 is an audio recording, and then 105 and 106 are the other 2 PDFs.
Okay.
And what is
So
this
we're
supposed to be?
now. Yes, could you repeat what this one is? Now that we found it.
Because this is my first time seeing this.
Sure.
Yeah, we've never
It is-
seen this.
This is Exhibit 103C. It is a record maintained by Ameren, Missouri of all of the customer contacts or other information that's kept with the customer account.
It's a lot of them, huh?
Yeah, this is.
It's a lot of them.
We don't have a problem with
more
this,
than that.
but we've never seen it before. But yeah, we don't have a problem with
It
it.
should be more than
Okay. So 103C, the contact logs are being admitted.
Okay.
This should be more than that. This should be more than that. It should be more than that.
We'll ask on cross if this is
Yeah.
all of them.
We can
Okay,
contact
you may proceed, counsel.
All right, thank you.
Like they
If you
just pick-
to page 3, there's an entry at the bottom that appears September 19th, 2021.
Yes.
And what is that entry recording?
That is recording. TOU stands for time of use. So it says time of use communications. This was a system generated contact, which is system is the all caps italicized at the bottom. That indicates how this information was added to the account records. And the customer, since they started their service September 1st, we do mail new customers that are defaulted to the evening morning savers time of use rate. We mail them an education explaining the rate that they're on. They're a new move-in, and I think it was mentioned earlier this morning that we do default customers who move into a residence where there is already an AMI or smart meter. We default them to the smallest time of use rate, which is the evening morning savers. So this simply states that on September 19th of 21, several weeks after the customer moved in and started new service, we mail them rate education advising that you are on this evening morning savers rate. You can access information for all of the rate options and make any different choice that you would like to make.
All right, Judge, I would ask the commission to take judicial notice of its stipulation and agreement and case number ER 2019-0335, as well as the order granting variance in case number EE 2021-0103.
Are there any objections to the commission taking official notice of those cases, stipulations?
Yes, we object. We had no knowledge of that.
We never received that in no mail or nothing. We don't even have that at all. That at all. Haven't seen that.
Well, it's
I'm just asking.
Go ahead.
Sorry.
I'm trying to understand what, we never even saw this at all.
Or the relevance of
the case. We never saw this at all. This is our first time ever having any kind of knowledge of this statement right here.
Yeah.
This form, this document, here, even in word of mouth.
Mr. Hernandez, you can respond if you'd like.
I'm asking the commission to take judicial notice of a public record that's in the commission's records from each of those cases.
I'm going to overrule the objection.
These, these. Okay, that's what we were trying to understand. We couldn't make out what she was referring to. No, he's talking about these right here.
Oh.
From other. Okay. No, we don't have an objection. I apologize.
Okay.
And no objection from staff, Judge.
Yes.
Thank you, Mr. Pringle.
It has nothing to do with us.
We'll take judicial notice of those case numbers, of the stipulations in those cases.
Okay, and this, the ER case is a stipulation. The EE case would be an order granting variance.
Thank you. Yeah.
All right. All right, going back to Exhibit 103, you were talking about the time of use communication that was sent to the complainants.
Yes.
Did the complainants contact Ameren, Missouri at any point in time to request a different rate structure?
From my recollection, the only request from the customer to change their rates, and the request was received August 25th of 23, where the customer, Miss Canada, mentioned that she did want to change from the evening morning savers to the anytime users, the basic flat rate. So yes, that was requested in August of 23.
And prior to August 23, 2023, what rate were they on?
They were on the evening morning savers rate, which is our smallest, the lowest incremental time of use rate that we have offered to our customers who have a smart meter or AMI meter. So they were on evening morning savers.
Objection. We had no knowledge of what rate we were on. When I requested that rate to be changed to around the clock billing, I found out from an outside source. Ameren never made us aware of, we even had the option of a payment plan. That's what I thought that you were referring to earlier when we asked to enter to judicial, that we never were informed of any payment plans or rate, well, not payment plans like an agreement, but there was no rate
We ain't have no
given
choice.
to us. We were informed of that by an ex-Ameren employee that there was a choice. Never upon setting it up was there ever any choice given.
I'm going to overrule that objection. It's another thing to maybe address and cross.
That's fine. That's fine.
It's cool.
That's
Let me
fine.
play dirty.
Ain't nothing that is that information.
And let them do that. That's how the court play.
Okay, Exhibit 103. Can you look at that document and can you explain to the commission when the customer requested the medical equipment registry information?
I can. So on August 29th of 2022, which would be shown on page 3 of the exhibit, there is a contact made. It was issued by batch process. It says MER, which is our internal lingo for medical equipment registry. So MER, equipment initial letter sent. So at that point, you can see in all 3 of those contacts that were made on August 29th of 2022, medical equipment pending. There was a start date, the equipment listed, breathing machine, patient, Aquilla, Canada. And at that point, we mailed out medical equipment registry paperwork to the customer. We sent that paperwork out that needed to be completed by a physician and returned to us in order for us to actually enroll the account in the medical equipment registry. And if you want me to kind of continue on, I can.
Yes, please go through all.
Okay. So on September 15th of 2022, you can see that there was an account contact listed that we were mailing another medical equipment registry form. We had not received anything returned to us at this point. And so the medical equipment was still pending at this point because we had not received the physician's information back in order to confirm the equipment and actually enroll.
Objection. We have no control over when or where. That's why you had to give us more than one, because we were trying to get that information to you. We have no control after we submit it to our doctor of when it returns at all. We were told that by the doctor that they were going to send that in. We had no control once we sent it into the doctor and walked it into the doctor as well.
I'm going to overrule the objection.
If you can continue.
Sure. So there's a contact left on October 17th of 2022 that there was a reminder letter sent out. And I understand that we, if we are not able to receive information back from a physician, we just send out a reminder that, we're still waiting for this to be returned. October 31st of 2022, you can see a contact that says the medical equipment expired. And that basically means that the pending request for enrollment in the medical equipment registry did expire because we did not receive anything in return. So we move back. If you forward to January 3rd of 2023, the customer again requested, Miss Canada requested medical equipment registry paperwork. So we resent this as well, January 3rd of 2023. It was not received. And you can see in regards to the medical equipment registry, so at this point, the account obviously has not yet been enrolled in the registry because we haven't received the correct physician paperwork back So in September and October of 2023, there are contacts left that we again mailed the medical equipment registry forms to Miss Canada and Mr. Clark's email addresses. But this does reflect the attempts that the company made to assist the customer in getting enrolled in the medical equipment registry.
And were there any other contacts regarding the medical equipment registry after the January 3rd, 2023?
What I mentioned on page 1 of the exhibits, in September of 2023, we sent the medical equipment registry forms, and then again, October 25th of 2023, we also sent those.
Okay. And has Ameren, Missouri received any of those medical equipment registry forms back from complainants?
We have not.
Or from the complainants' physicians, I should ask?
No, we haven't.
Okay. Let's see, if we could go to, turn to exhibit 105.
Actually, are the parties comfortable taking a 10-minute break at this time and recessing until 11:10? I'm sorry, this went a little longer than I was hoping to get a break in. Is that okay with everyone?
Fine with staff.
Certainly.
Yes, yes, that's fine with us as well. We were in the middle of trying to get something together, so that's fine with us as well, Judge. How do we?
Ask them, do they want me to send a picture of my CPAP machine and the document that I got right here?
He was asking if at this time we could send in a photograph of his CPAP machine.
If you have exhibits, you can try to email them to that thread we had yesterday. I think it has all of the parties on it.
Okay.
If you're able to do so, then that may be.
To the technology for real, man. So, that's why it's difficult for us.
Yeah, we apologize for that. But okay, we're fine with the recess. Actually, is there any way that, Judge, if it's okay, we could reconvene at 11:30 just so we can have enough time to get all this information over to you, or at least an extra 5 minutes or so?
How about 11:15?
That sounds good. That sounds good.
All right. We'll
All right.
go off the record.
Thank you.
Is everyone ready to go back on the record?
Yes, we are.
Okay.
Yes, Judge.
Yes, Judge.
You have your picture on?
I'm getting ready to, right?
Okay.
Okay, it is 11:15 a.m. and we'll be back on the record. And Ameren, Missouri, you may continue.
Thank you, Judge. I'm going to skip around exhibits a little bit. I'm getting some feedback. Is that us?
I don't hear it anymore. I did, though.
Okay. If I could ask the witness to go to exhibit 106C. Why are we getting feedback?
I'm still muted. My volume is all the way down. So I'm muted.
Okay. We'll keep going. Let us know.
I'm getting a little bit too, Jennifer. I hear it as well. Feedback.
Okay. We've tried to adjust our volume. Let me know if it becomes where you can't hear me or the responses. All right. Do you have exhibit 106C? What's marked
Yes.
as 106C? Okay. And what is this document?
So this is the medical equipment registry application that can be sent to customers via email or regular hard copy mail. That has to be completed with customer information and a provider statement before we can enroll an account in the medical equipment registry.
All right. And is this application form kept in the normal business practices of Ameren, Missouri?
Yes, it is.
And is this an accurate copy of that big business record?
Yeah.
With that, I would offer exhibit 106C into the record.
Okay. Are there any objections to admitting 106C? It is I don't think this is confidential. I think it's just 106.
It is public. I'm sorry.
Yeah, the medical equipment registry application. And I don't know if the complainants were able to see that. That's the last of the PDFs that were in that email.
I'm going to it now to see if we can.
Correct.
See that.
Sure.
I'm asthmatic too. Let them know that I got that machine too.
Oh, and I was able to send that information. I was only able to send it to Travis and Emily. So I just wanted to make sure I said that. I'm trying to open it now. Come on, open. Jesus. Okay, let's try that. Our last file is a recording. I'm trying to find the PDF one. Okay, I think I have it here. Okay.
Yeah, Ms. Canada, this is Travis Pringle from staff. If there was an email sent to me, I have not received it yet.
Oh, I've sent you about 3 or 4. Gee. Okay. Just let me know if it comes through. I'm not sure what's going on or why this is not. Okay, I do see this medical equipment form. What are we looking at on this? I'm sorry.
Did you want to object to it being admitted on the record?
No.
We want
Okay.
everything on the record, man.
And Mr. Pringle, did you have any objections from staff?
No objection, Judge. Thank you.
Okay. So Exhibit 106, the medical equipment registry application is admitted.
He's saying he's not getting my email.
All right. Thank you, Judge. And
If the
earlier
parties,
when we were...
hold on. If the parties can mute themselves if they're not speaking.
Okay, go ahead.
Okay. You may proceed.
Thank you. Earlier, Ms. Kirschmer, when we were going over Exhibit 103, you were discussing some entries that mention a medical equipment registry form being sent to the complainants. Do you recall? Is this the form that was sent to the complainants?
Yes.
Let me ask that question again just to be sure. Exhibit 106P, that was the form that was sent to the complainants.
Yes, medical equipment registry application, correct.
Thank you. Just wanted to clarify. If we could go to Exhibit 105C now.
Okay.
You have that in front of you?
I do.
What is this
And
document?
For the complainant,
Um,
sorry, this is the 5th PDF, if you can't see the numbers, so that you have ability to view it.
Thank you. Thank you.
All right. And
Okay.
what is this document?
These are copies of the August 22nd, 2023 and the September 21st, 2023 disconnection for non-payment notices that were mailed to Mr. Clark.
All right. And are these disconnect notices business records that Ameren holds in its normal practice?
Yes.
And are these accurate copies of the disconnect notices that are held by Ameren?
Yes, they are.
All right. With that, I'd offer Exhibit 105C for the record.
Okay. Are there any objections to 105C being admitted?
None from staff, Judge. Thank you.
I'm just now clicking to 105C. I was unable to look at the last one. I apologize, but I'm looking at it now. And if you could help me out, what is this document exactly?
This
is the, this is the first bill that we did receive. So, okay, I don't have a problem with this. I have this in my evidence as well.
Okay. So 105C is being admitted on the record as the disconnect notices. You may
All
proceed,
right.
Counsel.
Thank you. Thank you. All right. The first disconnect notice that's in Exhibit 105C. What is that disconnect? Why was that disconnect notice sent to complainants?
So the disconnection notice includes information in the first pink rectangular box about a third of the way down the page. It indicates that the utility service will be interrupted after September 1st for the reason of the first box is checked, past due balance. So there's also some additional information. It shows the amount due is $154.59. That was the past due balance at that time. And that payment was needed to be received by September 1st of 2023 to avoid interruption of service, which would occur as soon as the 2nd, the next day. Without looking at a calendar, I'm assuming as long as that was a weekday, business day.
All right. And were the complainants subject to disconnection when they filed their informal complaint with the commission?
Yes, we did receive a formal complaint, an informal complaint was received from the staff consumer services team on, if I remember correctly, August 29th. So at that point, they were subject for disconnection at the time that informal complaint was filed, yes.
And were complainants disconnected?
They were not, due to the pendency of the informal complaint case investigation. We were gathering information to provide to staff and for staff to investigate. We did remove the account.
Objection, a payment was made. That's why the disconnect did not happen. That's why the disconnect did not happen.
I'm going to overrule the objection. That should be saved for cross.
So we did remove the account from threat of interruption regardless of whether or not a payment was made, to allow time for staff to make their investigation. We removed the account from collections.
Okay. And then turning to page 3 of Exhibit 105C.
Yes.
This disconnect notice, what was this disconnect notice sent to complainants for?
This notice was mailed on September 21st, and this was for the past due balance of $311.49.
And were the complainants subject to disconnection when they filed their formal complaint?
Yes.
And once the formal complaint was filed, what did Ameren, Missouri do to complainant's account?
So since the amount in
Objection.
dispute formal complaint,
Hold on, Ms. Kirschmeyer. What's the objection, Ms. Canada?
The objection, the information that she stated is incorrect, sir. She just stated that the formal complaint was filed in the same time that the disconnect was sent. That was when they went through, I guess you all processed them. That these dates that she's giving are not the dates that it was actually filed on. Neither one of them are. So that's incorrect information.
Okay.
Those are the dates I guess it got processed. I'm not sure, but those weren't the dates that it was filed on.
I'm going to overrule that objection, and you can save that for cross. You may proceed.
Thank you. Go ahead.
thank you. So the amount in dispute when the customers or the complainants filed their formal complaint was $311.49. So what we did was we suspended those charges. So it basically pulls it away from any amounts that are currently due or collection action can be taken on. That $311.49 has been continued to be suspended during the pendency of this formal complaint proceeding. So that clearly took the account out of threat of interruption after October 3rd, since we suspended the $311.49.
Okay, and are any of the disconnection notices in 105C within the cold weather rule period?
No.
In regard to the cold weather rule, can you explain the registry process for elderly or disabled customers?
So there is a special section within the Commission's cold weather rule that allows for low-income, disabled, or elderly customers to register with their utility under this cold weather rule registry, which allows for additional notifications if the account were to be subject to disconnect. It also allows for some different payment arrangement options that would not be available to customers that are not enrolled in the registry. And Ameren, Missouri has a wide range of options, energy assistance options, health and safety options available to our customers. And our Caring Contact program is one of those options. And the Caring Contact program allows for customers to become enrolled in a third-party notification registry, which is satisfies the requirements in the cold weather rule for that particular low-income, elderly, or disabled registry. And so we do offer a Caring Contact program to customers to fulfill that requirement.
And did the complainants register under the Caring Contact program?
No.
And is the Caring Contact program different than the medical equipment registry application?
Yes.
How so?
So our medical equipment registry, which since we did include this as Exhibit 106, this being enrolled in our medical equipment registry allows customers their accounts to be coded as such, and they will then receive advance notice of planned outages so they can make alternate arrangements. For example, if we were planning to do some work in the area and the service was going to be out for 8 hours, we would want customers enrolled in our medical equipment registry to be aware of that so they can make alternative arrangements for their equipment since they would be out of service. We can never guarantee uninterrupted electric service, but it is clear on the application for the medical equipment registry that just because a customer is enrolled in this program, it does not prevent disconnection of electric service for non-payment. It doesn't provide any priority restoration of utility service during an outage. What the medical equipment registry does allow for is there are levels of medical equipment, and if the equipment is considered critical, we have, there's special handling of these accounts by our customer advocacy team within our energy assistance group or credit group that, and I'm not certain, I'm not an expert on all of the different types of equipment and where it falls as far as critical or non-critical, but I do know that a CPAP machine is not considered critical equipment because it can be easily transported to another location, but there would be certain equipment that is critical. And if a customer enrolled in the medical equipment registry is coded as having critical equipment, then we would take certain handling to ensure that if that account were to come in threat of non-payment disconnection, we would do certain handling and make extra efforts to, I know that we have like load limiters, which if the account got to the point where energy assistance wasn't able to help and we had tried everything we could to get the account paid up to date, we would install perhaps a load limiter on the meter, which allows for a certain amount of electricity to be used, which could support the critical medical equipment, but it wouldn't be enough to run everything that runs in the home. So that's the medical equipment registry. The Caring Contact Program is separate from the medical equipment registry because it's not related to medical equipment at all. It's related to whether or not the customer is low income, elderly, or disabled, and they have to meet certain guidelines. I think it's 150% of the federal poverty limit. They have to file an attestation stating such. So it, like I said, it's not related to medical equipment though. It's related to low income, elderly, or disabled.
You may have answered this, but just to be sure, the complainants did not register as elderly or disabled under the cold weather rule. Is that correct?
That is correct.
Okay. And even though someone is registered as elderly or disabled, does that always stop all disconnection processes under the cold weather rule?
It does not. So under the cold weather rule, if a customer is registered low income, elderly, or disabled, that does not mean that we will not disconnect their service during the cold weather rule, which just to clarify or put it out there, the cold weather rule runs from November 1st through March 31st of every year. And we have, there's, special rules in place during this time frame. But being registered on the low income, disabled, or elderly registry, which would be our Caring Contact Program, does not mean that we will not connect from November 1st to March 31st. What it does mean is that we will send extra notifications as required by the rule and covered under our program.
Thank you. Have you reviewed the staff report in this matter?
I have.
Okay. And in the conclusions of the staff report, it mentions that staff is encouraging Ameren, Missouri to look at ways we could provide additional information to customers regarding being registered as low income or elderly disabled under the cold weather rule. Do you have any, has Ameren, Missouri done anything since the staff report's been filed in terms of that recommendation?
Yes.
And what have those actions been?
So I've actually reached out and had several discussions with the manager of our customer advocacy team. Wanted to share staff suggestion and think of ways that we could be more proactive on our customer calls, specifically within our call center, to without overstepping any customer privacy concerns. That's something that we have to be mindful of. We do want to look for ways where we can be more mindful of identifying customers that may benefit from the Caring Contact Program and be more proactive in the outreach. So we have already had several conversations and plan to have many more conversations over the next several months. So hopefully we can have something more definitive and implemented before November 1st, which is the start of the next cold weather rule.
Okay. I think I heard you have some concerns with staff's recommendation. Can you explain what your concerns are?
Well, some of the concerns would be, I mentioned overreaching. We certainly don't want to pry into a customer's. There are definitely indications when one of our customer care advisors is on a call with a customer. I know there is a little bit of feedback, and I'm not sure what it is, so I apologize. There are definitely indications that can be seen from viewing the account. Maybe I'll move back a little bit. There are some indications such as whether or not the customer has received energy assistance in the past. That would be an indicator that perhaps they are low income if they were able to apply for and be approved for energy assistance. So that would be an indicator. Obviously, if a customer mentions, I don't think in mentioning medical equipment in and of itself would be an indicator that a customer is disabled, for example. So that may not be the right, indicator to look for. But I do think that there are concerns with, we wouldn't want to ask customers necessarily outright, are you low income, elderly, or disabled? So we'd have to just be very mindful of that. And I think that that's something that our customer advocacy team is really great at working through, coming up with ways that we could both help our customers without being too intrusive. So.
Okay. If you could give me just a minute, Clark, I just want to make sure I don't have any more direct questions. I think that's all I have for direct. I'll tender the witness for cross-examination, but I would like to reserve recalling Ms. Kirschmeyer based on staff's opening this morning saying that they were changing its recommendation or its findings. I would just like to be able to recall our witness based on any of those changed findings of staff.
Okay, that's fine. Is there any cross by staff?
Yes, Judge, thank you. It's still morning. Good morning, Ms. Kirschmer. And do you have a copy of what has been entered on the record as Exhibit 101C in front of you? Oop. And do you have that, Ms. Kirschmer?
Yes, can you hear me?
Yeah, I can hear you now. There we go.
And let me mute my computer and let her turn on her audio. Maybe that will help.
Think that's better?
Can you hear me now?
Yeah, the echo got worse.
Okay. Oh, now try. Now I think it's better.
Yep, now that's good. That is good.
Yay. Okay. Yes, 101C, I have that in front of me.
Yeah, and I don't want to go to in camera if we don't need to. My question is just going to be asking you to define a term in the far right column. Do we need to go to in camera for that?
Sorry, what is this exhibit?
101C, Judge.
101C. I don't believe we would.
And yeah, I just want to make sure if Ameren's is going to have just do with well, pretty much the definition of the first term in the far right column.
Cash concentrator, I think we're fine.
Yeah, go ahead. I don't think it's confidential.
Right.
All right. Well, then, Ms. Kirschmer, looking at Exhibit 101C and the far right column where it says cash concentrator, can you define that for us?
I sure can. So a cash concentrator payment is a payment that's made generally from a originator that we don't have a contract with. So the most common cash concentrator that we see payments coming from are like the walk-in non-partner payment locations, such as a Walmart, for example. And from my experience, generally the customers that are using an insurance company payment to make payments generally will go to one of those payment stations. Without asking directly the customers, I wouldn't be able to confirm that, but it's generally a payment made at a non-authorized payment station for Ameren, Missouri. So it's not at one of our authorized, like a Schnucks or a Hy-Vee. It's probably made at maybe a Walmart. It could be also an online bill payment service that we don't work directly with.
Thank you, Ms. Kirschmer. And actually that tied into my next question where, can you describe to us your understanding of how the complainant's payment arrangement works? They were talked about United Healthcare and Aetna. You kind of touched on that. Can you explain to us just how that kind of arrangement works, at least from your understanding? And is that a pretty normal arrangement that Ameren sees pretty regularly?
I will admit that I've very limited understanding of this, but as a high level, what I understand is that customers maybe on Medicare or Medicaid receive payments from receive payment from their insurance company, United Healthcare or Aetna, that they can use to pay certain utility bills, perhaps. And generally, from my limited understanding of it, is that these are taken to a walk-in payment station to be paid. But I think maybe if it's a debit card, they can actually pay it online with that debit card number as well.
And are you aware, is this an arrangement that Ameren sees fairly normally, or is this a little different from the typical payment arrangement?
And I wouldn't say payment arrangement, maybe just form of payment, just because I don't want to muddy it with, it being a payment arrangement that we've offered. But I do think that this has become more common, probably since the beginning of 2023 is the first that I can recall personally hearing that customers are increasingly paying their bills through this payment form.
Thank you for that, Ms. Kirschmer. And I want to ask you about, you kind of touched on how to better identify if customers qualify for services, specifically under the cold weather rule. Could you just give us, I guess with this hypothetical, if an Ameren customer service rep gets a call from a customer and the customer says they believe they qualify under the cold weather, how would the Ameren customer service representative proceed after that?
So to be honest, the cold weather rule to an advisor is a customer who's asking for a cold weather rule payment arrangement. And that is how we commonly refer to it internally, is cold weather rule. That means that the customer is asking for the payment arrangement, which has has specified terms under the Chapter 13 rule, where we allow a much lower down payment and then spread the balance over the 12 monthly installments. So generally, we give specific cold weather rule training to customers generally, or to our advisors rather, at the end of October in preparation for the start of cold weather rule season, November 1st. So if, to an advisor that has a customer call and says that they would like to, they're interested in the cold weather rule, that is going to flag the advisor that they're looking for a cold weather rule payment arrangement. So I think there's not, to register, it is hard, I think, when customers call in that maybe there may be a lack of communication, a lack of understanding. So if a customer calls and says, I want to register on the cold weather rule, the advisor's first thought is going to be, they would like the payment arrangement. Let me see what payment arrangement, if you're eligible for this. Also, our advisors, if customers are calling about a cold weather rule payment arrangement, they're also inclined to offer energy assistance. because in the advisor's mind, I'm speaking in generalities, of course, and I was an advisor for 8 years myself on the phone, so I kind of have some experience with this too. But in the advisor's mind, they're saying, this customer needs some assistance. What can we do to help them? Let's see if they're eligible for a cold weather rule payment arrangement. And if that for some reason isn't an option, okay, let's try to get you some energy assistance. There's a list of agencies that you can try to reach out to try to get some help with your bill. But if on a phone call, if a customer is saying, I want to register under the cold weather rule, the first thought is not going to be that they're interested in this caring contact program, because that's really not offering them any financial benefit. That's really not helping that customer pay down their bill and get it to somewhere where it's manageable so they can catch up. So that's why it wouldn't be the first thought. But as you mentioned, we are going to explore some options where maybe we can make it more prevalent in the advisor's mind that at least it's mentioned when customers call and say, I want the cold weather rule. Here's your options. Here's a payment arrangement. Here's some energy assistance. And we also have this caring contact program, which would allow you additional notifications if your account were in threat of interruption. I hope that answered. It was kind of lengthy.
I was hoping for a long answer like that. I wanted to kind of see the whole process. And just for the record purposes, when I was saying customer service rep, the correct term is advisor.
It is. You know, we've changed so many times over the year, but currently it's an advisor, yes.
Okay. And then when you talked about the energy assistance options besides a cold weather rule payment arrangement, putting forward those energy assistance options, is that part of the October training the advisors receive before cold weather rule season kicks in?
Definitely. And not just, we offer, for example, LIHEAP is getting ready to end the end of May. So we're always sharing this energy assistance option information to our advisors because we want them to promote, and they do promote this as an option to a customer who is not able to make their full payment.
And when you were talking about preparing for any kind of new training for this year's cold weather rule season, is the company would the company be comfortable with working with staff to come up with any kind of extra training if needed?
Speaking from Aubrey Kirschmeyer right now, I would say absolutely yes. I would certainly want to collaborate with my coworkers to make sure, but I think so, yes.
All right. And then my final bit of questioning, and hopefully this will make it so you don't have to be recalled later. Do you have access to DR13?
Yes, I do. I actually do.
And Judge, I didn't plan on entering this as exhibit, but if you would like for me to email a copy to the parties so that they can follow along, I can. Just let me know your preference.
Yeah, I'd appreciate that if you can email it.
All right. And just give me 1 second. I'll send that on that the thread with Ameren's exhibits. So you'll also have this as well, Ms. Canada and Mr. Clark.
So Travis, you're sending that right now.
You're muted, Mr. Pringle.
Yes. Yes, I'll be about to send that on the email thread that Ameren started yesterday with their exhibits.
All right.
And since it is close to noon, are the parties comfortable with just proceeding through this, or would anyone anticipate or like a lunch break in case? I know we only have one witness left, I believe.
Yes, we would love a lunch break if that's okay.
Okay. Well, we'll see where we get to after Ms. Kirschmeyer's, the cross-examination for Ms. Kirschmeyer.
Tell them you have a question
Okay.
to do before we go to lunch break.
Okay.
I'm still, I haven't received the email yet, so I'm just waiting so I could show that to the witness.
All right, there we go. All right. I just emailed that out to the parties. Please let me know, Judge, Ms. Canada, Mr. Clark, when you have a copy of it.
It just came through for me.
Still waiting. That's a little further to go maybe to our service.
Mr. Clark said that we have it.
Okay. And this also, Ms. Christopher, I don't want to touch on any of the addresses of the complainants. Besides the addresses, is there anything else here that's confidential that we should go in camera for?
Gang of it. Answer which one we opening up.
Did you send it to me?
He said, I'm sorry, Aubrey, I didn't mean to do that. Travis, we're trying to figure out which one of these that you're wanting us to take a look at.
It came with 7 attachments.
I just sent one, so it should just be named, DR13.
Yep. And Ms. Hernandez, you are copied on this email as well.
Yeah, I'm thinking maybe we didn't receive it because if
It
it's in
came in, did what he just sent.
an old format, it won't go through our cybersecurity program.
It has to be a doc.
Oh, there, it just popped through. It's taken a while to get to our,
Extra security.
to the witness. Just one moment.
I'm having to preview everything on my computer because it's not like in my Adobe.
Yeah, I'll just do this. I can see it perfect. Just like that.
I'm sorry. I'm sorry to interject again. Travis, we are having a problem as well, along with everyone else. It's not saying DR13. It just says 7 attachments, and it doesn't verify which one is which.
It came with Travis
Ms.
and
Canada,
Jennifer.
it should have been sent to your email account, not
Yes,
Mr. Clark's.
yes, he's in my, yeah, he's in mine. But there's other attachments to it. I'm
That's
just
the first
repeating
one that
what
popped up when he said and everybody get it. It popped up as soon as he said it, but it says 7 attachments.
Well, it's the 2-page document.
What is that?
It said, "Good afternoon."
Okay, scroll down. Okay, we're gonna go back on mute while we try to get it.
All right, I guess it's this.
Yeah, Ms. Canada, I'll send you an email with that DR. It's just to you, so maybe that it won't be on the thread with all the other attachments. Maybe that'll be easier for you. So I just sent it to you again, this time with not on a separate thread. That way it shouldn't get.
Okay,
lost in all
Travis,
the other
thank you.
That's the is this.
Um,
File number EC.
No, that's our case. He said he's just sending it by itself, so go ahead and see if you see it. Okay. Thank you, Travis. I appreciate that.
Okay.
All right.
I see the DR13 now.
Okay, that's the
That's
one.
the document.
Yep, that's what we're looking at. Okay.
So we'll click on it and open it up.
Yes.
Yep, and that's what I'll be questioning Ms. Kirschner about.
Yeah, he's
Okay.
not admitting it, so, or not
Okay.
offering it, at least yet, if he does.
We still trying to.
Okay.
We gonna
Thank you.
get evidence in to us.
You may proceed, Mr. Pringle.
Thank you, Judge. All right, Ms. Kirschner, and you have that document in front of you?
I do.
All right, and so really I just want to talk about the outbound collection call. Mainly everything with those 4 asterisks at the bottom of page 1 and below.
Okay.
Do we need to go to in camera for this?
Nope, I see it.
I mean, I don't think so. The only thing is their informal complaint number is listed, but
Yeah, I won't be bringing that up.
okay. Yeah, I don't think so.
All right, so
Okay.
then, when it came to the outbound collection calls, you're aware of the stipulation agreement that required the 2 outbound calls 2 to 9 days before disconnection, correct?
Yes.
And you're aware of the case number for that?
Not off the top of my head.
I have it right here. It's, in case you'd like to check it, it is EE 2019-0382. Does that ring a bell?
Absolutely, it does. Yep.
All right. So can you just kind of explain to us what happened with the outbound calls?
So actually, so what we are required to do is notify a customer through a mail disconnection notice, two outbound collection call attempts within 96 hours, and then a final 24-hour disconnect for our smart meter or AMI customers, of course, which Mr. Clark's account did have. So on March 2nd was the date that the system was scheduled to make the outbound collection call attempts. And there were, and let me just explain a little bit more. So when we make those two outbound collection calls these are the ones that are not the 24-hour disconnection call, but the two call attempts, if there is a live answer on call number one, we don't make a second one because we have reached the customer. If there is a busy signal or an answering machine reached on the first call attempt, we make a second call. We reasonably space them out to try to actually reach the customer. So they're not back to back. There's generally several hours in between. So on March 2nd, when the two outbound collection call attempts were made, there was an answering machine reached on the first one. And the system should have recognized and known to make a second call attempt later in that day. But there was a system issue, which we discovered, that prevented that second call from being made. So there were several accounts, or quite a few accounts, that were involved in this system issue that did not receive two call attempts for the 96-hour call if an answering machine was reached on the first call. Now, if there was a busy signal on the first one, the system was still making the second call, but it was only if an answering machine was reached on the first call, there was not a second call attempt made. So we identified this issue. Actually, it came up in an informal complaint that we were working on back in March of 2022. So we identified this issue, immediately took action to rectify the issue, work internally to get the system issue fixed. There were some accounts that were still disconnected. We did everything that we could to make it right and get it fixed as quickly as we could. But it just so happens that this account, Mr. Clark's account, was involved in that system issue where on March 2nd, we only made one call attempt, an answering machine message was left. So we sent the disconnection notice. We only made one of the two call attempts within 96 hours. And then we did make the 24-hour call, and there was a live answer on the March 3rd 24-hour disconnection call for the AMI meter prior to the interruption of service on the 4th. Now, you mentioned the enhanced disconnection schedule, which does also call for text or email alert notifications. Now, those can only be made if the customer is enrolled in our text or email alert program. At this time, on March 2nd, this customer, Mr. Clark, was not enrolled in that. He did not roll into alerts until after the service was disconnected on March 4th and had a conversation about getting reconnected. And at that time, the customer enrolled in alerts. So we couldn't send the text or email alert because the customer wasn't enrolled in alerts, if that makes sense.
Yeah, no, thank you. And like you said, when it came to the second call, Mr. Clark's account was not the only one who was affected by the first call going to an answering machine and a second call not going through.
That is correct.
And then also when this incident happened, the company also alerted staff of this at the time when the issue was recognized?
Absolutely, yes.
And since you took the steps you outlined to rectify the issue, has Ameren had this problem since?
To my awareness, no. Not that I'm aware. I think we've made a permanent fix back in March of 2022, and this has not happened since.
All right. Judge, I have no further questions for Ms. Kirschmer, but I would ask that the commission take judicial notice of the unanimous stipend agreement in EE 2019-0382.
Okay. And are there any objections to taking judicial notice of the stipulation and agreement in that matter?
No objection.
Okay. It is admitted.
Thank you,
Sorry,
Judge.
we're taking judicial notice of it.
Yes, yes, usual notes, yes, thank you.
Is there any cross by the complainants?
I'm sorry, could you repeat that, Judge?
Do you have any questions for Ms. Kirschmeyer?
Yes, I do, several.
Okay, you may proceed.
Okay, this is why I was asking about taking the break, because I know we're gonna run into the noon time, in my questioning, but and I don't wanna be rushed. I do wanna be able to have time to, ask all of my questions, just like, Ameren was allotted to have
Okay.
their time. But I'm gonna start a little bit backwards, if that's okay. So we can go with what everyone is fresh in their minds with in reference to the CPAP and the cold weather rule. If that's okay with you, Aubrey. So we're gonna work a little bit backwards in my questioning, if that's all right.
Yes.
Okay, so I want to start with you mentioned that a call was made and there was a live pickup. Who picked up that call? And if the system was having difficulties, how was Ameren able to determine if it was a voicemail or a live call or an answer at that time, if there was these system issues? I mean, how were you able to determine that?
Sure. Well, and the system issue was only related to calls that were answered by the answering machine. And this may be a little out of my realm of expertise because I don't work directly with our telephone team, but the system does have a way, the outbound collection system that we use does have a way of determining whether or not it is an answering machine that's picked up or a live person. I'm not aware of all of the specifics related to that, but I mean, I think I've experienced it myself with calls from companies to my personal phone where sometimes it doesn't talk until you actually answer. So to be quite honest, that's probably out of my realm of expertise as to how the system can determine whether or not it's a live answer or not.
I appreciate that honesty, I do. However, quick question in reference to that. Do you have in front of you whose phone number that did call at that time?
I probably, based on the exhibit I'm looking at, 103C, which is the account, the company records of the account contacts, the phone number listed on the account, and honestly, I'm not certain. As of right now, I can tell you that it was probably ending in 3522.
Okay, and what date was that you have for that phone call being made and the machine picking up? I mean, I understand that you're not sure exactly the technicalities, but.
Well, I can't actually answer that without probably looking at your account. I can tell you that the call was made on March 3rd. But as far as what phone number was looked at, I would have to review the company records at that time so I can see what was the phone number of record at that time.
You don't have that information in front of you at this time?
I don't.
Okay. I would like that noted, please. Also, another question that I have for you. If a customer, and we're just going to speak in general, just not necessarily our account, but just in general, of course, with emphasis on our account. If a customer is paying their bill on a regular basis, and the advisor, as you all are calling them at this point, if the advisor does not make the customer aware, and with you all not knowing what their disabilities or what issue that person might be having, are they trained to volunteer this information? Because I know that nothing was volunteered to us particularly.
To clarify, are they trained to give what type of information?
To make us aware of the programs that are available, what different resources we have, the cold weather rule, all of these type of things. Are your advisors trained to tell us this information right now? I mean, I understand what you're planning to do, but at this time, are they trained to inform the customer of all of their options as far as assistance, the cold weather rule, how to register for those options, and so forth?
Yes, our advisors do have training on all of the different energy assistance and financial assistance options that are available to customers, and are trained on where to direct customers to find out more. So, for example, there's a lot of information available on the website that will give all of our health and safety and financial payment assistance options to a customer. And at some point, the customer is maybe directed to research that themselves to find out what the best option is. But I know that energy assistance is always highly promoted, as well as the payment options that are available to customers.
So if the customer does not have the ability, as we've all been able to see with just this hearing in itself, I mean, I've had difficulties even trying to be able to follow along. If the customer is unable to utilize the website to find this information, does the customer have to ask about these programs, or does the advisor say, hey, we have a cold weather rule in effect that you might qualify for, because that was not done, or the assistance that is available to you if you can't, my disability is blindness, for example. I have no way of being able to utilize the website for that purpose to actually find this information. The advisors that we spoke with did not volunteer this information. I had to ask. So is that how they are trained? If the customer asks about it, that's when they are informing? Or is it a thing where they're supposed to inform us without us having knowledge of it already?
As you can imagine, each customer call is different, and depending on how the call flows, I do know that if a customer has indicated a financial difficulty, that energy assistance information doesn't have to only be obtained through our website. We can mail a copy of energy assistance agencies. You can actually hear them through like our voice response unit. So, but
yes or no? That's all. I understand your explanation.
Yes or no to?
Does it yes or no?
Yes or no to what's the specific question that I could answer yes or no to? I'm sorry.
The question was, are they informing the customer, or does the customer have to question the availability?
I would say it depends. The availability of all of the different payment options or energy assistance, or
anything that might be listed on the website. Because as you stated, there's no telling what a particular person's disability or issue may be. I was just simply asking, are they informing? Are they trained to inform regardless of the issue? And I understand wording is the issue, but is this a simple yes or no? Are they told to say, this is what you have as an option?
yes, the advisors are trained on what different options to provide to a customer.
Okay, that's fine. All right, I have another question as well. So if they're trained on that to ask these questions to, I guess, individualize each customer, I guess you would want to say, at what point are they supposed to ask if they meet the qualifications or not? Do we have to indicate that?
Well, I don't know that an advisor would necessarily ask a customer point blank whether or not they met the certain requirements. They would likely explain to them, as you were explained when you're asking about medical equipment registry, that the requirement is that this has to be completed and signed by a physician, for example.
Well, what about the process of the steps to do these registries with the cold weather rule, with the medical equipment, so on and so forth? Are they are they supposed to? I don't even want to say are they supposed to, but I know in our personal experience, they have not told us flat out. So I'm asking you all, is this something that they are told to do to find out if the customer qualified, and what is the process and the steps that they're supposed to take to register?
And maybe I could answer this by explaining to you that actually this morning I went back through the calls that that were made on the accounts, both on Spruce and Waldorf, and there were actually only during cold weather rule, which I mentioned runs April 1st through, no, I messed that up, November 1st through March 31st. So you made some calls in March of 2022. After the service had been disconnected. So there weren't any calls made prior to the disconnection for non-payment where we would have had the opportunity to discuss any cold weather rule registry options with you. And then you did make some calls on several calls on January 3rd of 2023, where I listened to the calls and you discussed not being on the medical equipment registry, and that information was again sent to you again, but there was nothing that I personally heard when reviewing the calls that would have even prompted me to think that you were asking about registration under the cold weather rule registry. So
in just mentioning the cold weather rule, and I mean, if I was to say, hey, I understand that there's a cold weather rule in effect, by me saying that the advisor is not trained to elaborate and explain the process to be able to use that as an option.
And as I mentioned to Mr. Pringle, I think that if you were to call, if you or any other customer were to call and say that I would like some information about the cold weather rule, the advisor would give you information about what your option for a payment arrangement under the cold weather rule payment arrangement would be, and or point you to resources available for energy assistance.
Okay. Well, you had mentioned something about if someone met the 150% poverty level without the advisors asking the questions, whether it's offensive to the customer or not, how are they supposed to inform you or even go about the process of submitting the information to let you know that they qualify for that?
Well, the caring contact registration application can either be found on our website or it can be mailed to a customer. And there would not be any discussion, in my opinion, from an advisor to a customer getting into the nitty-gritty of what the application requirements are. So that would really be, I think it's our job as a company to let you know what the options are, and then it's your obligation as a customer to decide whether or not you meet the requirements.
So would that require, so that would require us being informed of the process then, correct?
You would definitely need, but if you were interested in signing up for Caring Contact, yes, you would need to be advised about that, and we're either sent a form or directed to a website where you or someone that was able to assist you could print that off for you.
Okay.
Yes, I would agree with you, yes.
So okay, thank you. When did you notify us of the cold weather option or the registry being available? When did you notify us of that? Or was that something that we called in and asked or mentioned when you reviewed our recordings?
I did not hear any call where you specifically asked during cold weather rule whether or not you could be eligible for or receive information about the cold weather rule, low income, disabled, or elderly registry. I did not hear any calls where that was discussed.
Okay, well, I would like to have reviewed the recordings in October when I was informed by the commission about the cold weather rule. If you would review those recordings or have those reviewed, and I don't know how you all do that, but at that time in the month of October, I did ask about the cold weather rule so that by November we would know what to do. But we'll move forward. The next question that I have is, when have you ever notified us of any of these services, or did we notify you all that we had knowledge of them?
Can you please tell me what specific services you're referring to?
Well, not just the cold weather rule, but even with the medical review, I recall a conversation that we had that I mentioned that Mr. Clark was on a CPAP.
Option you're referring to, but generally it's when the customer reaches out to us, we provide them whatever options are available at that time. And so on any call interaction that I was able to review the calls, you know, the customer will tell us what they're needing on the call, what their question is, and then we will do our best to respond appropriately and provide you with whatever information you're needing at that specific time.
Okay.
I'm sorry, it's a little general, so I wasn't sure which one to point to.
I appreciate that answer. That's fine. That's fine. Okay, so we're gonna move on from that. Let's see here. My next question would be, you mentioned earlier in your testimony about the additional charges section of the bill. You said that you all now call that the additional, what was that again?
Additional adjustments?
Okay, so if that has been changed recently, you said that was done in September of last year, that would not be relevant to us since we stopped doing any overpayments in June. But with that being said, when we look under the additional charges, I'm not sure of what example it would be, but the bill that had the 108.82 amount, when it was listed as additional charges in the details section, it said deposit. Why would that be listed as a deposit and there was no deposit amount required?
And I could definitely answer that for you. I don't have this specific bill that you're referring to, but I know that I have this in my mind because I remember looking at it. But I think the problem, and you did say that you have difficulty with your vision, so completely understand where it's easy not to see, but it says deposit in that additional charges section, which is now referred to as additional adjustments, but there's a little negative in front of it, which means that it's subtracting from the balance. So it's not an additional charge. So that was your final bill. And so we were holding that $18. I'm sorry. I know there's a lot of feedback. We're trying to back up. We were holding, that was the deposit amount that we were still holding on the account on Spruce when you closed it out. So then when a customer closes out their account, we refund any deposit that we've been holding. So that deposit amount was a credit. So it would have been, and Jennifer got it for me. So, so it says, so you're referring to the bill for it was a total amount due of $180.53. It is page 91 of 112 on Exhibit 100. So this was your final bill for Spruce.
Yeah.
And the additional charges section states deposit applied, and it's minus $18.33. So that means, yes.
I was just strictly wondering why it just says deposit. I understand how to read the bill.
It says deposit applied.
Right. So the deposit applied, we were informed by yourself and Terry that they're not, the credits are not supposed to be used without authorization. So why were these credits applied without us saying that this is what we would like to use it for?
And if it was used to close out the account, why is you stating that we still owe y'all on that account? If it was used to close out one account, why is y'all stating that we still owe for our account? If you use our credit to close out the account, close is closed. Just told on yourself.
So, and I apologize, I don't recall ever advising you, and if you were ever told that certain credits have to have customer authorization before being applied to an account, I apologize because that's not the case.
If they just made it on record,
You work directly with Terry, correct?
I do.
Okay, that was who informed us of the authorization being necessary.
And you just stated out of your own mouth there was a plot to close out account. You just said.
Well, I'll move on. I'll move on, long as that has been notated. Moving forward, I'm gonna go back a little bit to the questions that I had in order for this, so I'm trying not to overlap. So I'm gonna go back to my first question, and hopefully I won't run into any of the other ones, but I appreciate your answers. All right, so number one, the rule, I believe is CSR 24013.2, .0220, billing and standards. This rule establishes reasonable and uniform billing and payment standards for resident services to be observed by the utilities and the customers. It's stated on number 2, each billing statement rendered by a utility shall be computed based on actual usage during the billing period. So the question is, where are our provided tariffs, reflecting the estimate versus the actual usage before the seasons change? So what I'm asking you is the actual usage being billed versus the estimated amount. How were you able to figure that out without anyone reading the meters? I understand it was an AMI at Spruce, but when we came here and we asked for around-the-clock billing because we were no longer in a residential property as far as an apartment complex, when was the actual usage used to determine the billing to make it be that high in July without any cooling being available? There was no AC then or no AC now.
Well, I'll try to break this down, my response break down into a couple of different sections. I first want to clarify that you had an AMI smart meter at Spruce as well as at Waldorf. Your meter type has not changed at all. The only thing that we changed in August of 23 was we changed the rate that you were being billed on. Instead of being billed on the evening, morning savers time of use rate, you requested to be billed on the anytime users rate, which means you're billed the same, a flat kilowatt hour charge, no matter what time of day.
Yep.
Correct. So, I also, when reviewing your both your statements and your bills, our company records, you've never had any estimated bills from September of 21 through the present. You've always been billed actual, and just so you know, we get your readings electronically.
Mm-hmm.
So we don't have meter readers and haven't for some time. So your meters, your meter reads are obtained. Basically, there's a module inside the meter that shoots out the reading to, and once again, I'm not a metering expert by any means, but we're able to electronically obtain your readings several times a day.
Okay.
And so we actually do obtain the reading, not with a person looking at the meter, but electronically.
Okay, so when, if at all, do you all come to check and just make sure that the information that you're receiving at the office is accurate to the meter that is being set up? Because this is an older property, so I'm asking, for this to be an AMI meter that you're reading. Why at any time when I set up the service at the new address from the last year even, and we went from the city to the county, we're just trying to find out, again, you said that nothing is based on estimate. However, we have email communications from you saying the estimated usage amount, the projected amount, and then the bill comes, and regardless of our recalibrating our usage, it just so happens to be that exact amount that was estimated. So
the exact amount than it was the previous year and the year after that and the year after that. The same exact amount.
So
That's all
we're just trying to find out, do you all, if ever, come out just to make sure that the information you're receiving is accurate to the physical meter? Like if you receive an email and you get hard copy mail through the mail,
Yes, sir.
we're just asking on the record, what exactly, when do you all ever see, okay, let me make sure this is right?
Came from the office to my house.
Unless there is some indicator that there might be an issue, whether there's an estimated read or if a customer requests us to come take a look at the meter, then we would do it at that point. But if everything is running fine and you're being billed actual usage and there aren't any fluctuations, there would not be a need for the company to go out. And we do, if a customer requests a meter test, we will come and test the meter. We will always give you the option to be present for the meter test. And then we will send you a letter with the meter test results afterwards. And from my review of the call interactions you had with our employees, there was never a request for Ameren, Missouri to come out and test your meter because you thought there was something wrong with it. So.
Okay, so on the recordings that you listened to, there was a comment when we did our estimated, and I'm so sorry that this stuff has not downloaded to you all via email, but on one of the bills, the estimated projected amount of usage, it stated that we used $127 in the month of July for cooling, but just like now, in July, we did not have AC. It was turned off at the main breaker. So that's why I'm asking you if these estimates are correct, if these AMI readings are correct, because if it's saying that we use 127 in cooling our property, but we did not have an AC that month, that would kind of initiate a question mark for me. So I'm just wondering why that didn't initiate it, because I know for a fact that on that recording, I reviewed it myself, we did say to the advisor, we don't have AC right now, and I do have a bill with that evidence that I sent in from the appliance guy saying it was not serviced till August.
So I think I can answer this for you to some extent, Ms. Canada. You have been on and off our email alerts over the course that you've had this account open. And I vaguely remember the call that you're referring to. So we have many different billing and payment alerts that we send to customers. So without looking at the exact one you're referring to, I probably won't be able to get too specific since we weren't able to see your exhibits yet. But our bill projection email alerts, those can sometimes be general. We use a vendor to that creates and sends these out for us. And I will say that there are times that that bill breakdown that I think you were referring to, which says, 60% of your usage to date this month has been from AC and maybe 20% has been from refrigerator. That is AI generated. And unless a customer goes onto our website and completes a specific employee profile where you can enter in which type of appliances you use in your home, there's always the potential that AIs that may be a little skewed in that breakdown of what they think that your usage came from. Because obviously we're not at your home. We're not, physically seeing, what breakers are using what. So it's a tool that we use that is pretty fairly consistent. But there may be times where it's a little bit off. And if you were to go online and complete that profile, like I mentioned, it would probably be more tailored to your usage. And when you see the estimated projection.
Go ahead, though.
No, I was just going to explain, and I understand too. I think I understand your confusion where you were receiving an email from us that says your estimated bill projection for the end of the month is this.
And
That
then
doesn't
that's
mean
the amount that the bill would be. That's the amount.
Hold
that
on.
the bill would be.
Can we not
So-
interrupt while a witness is answering a question? Let
Yes,
her
I'm
finish her
sorry.
question
Let
and
me
then
go
ask
back on
next.
mute. I'm
Yep.
sorry. I thought I was on mute. I'm sorry. I'm
That's okay.
sorry.
Thank you.
So, no problem, thank you. So that may be sent 10 days into your 30-day bill cycle. And so that's saying we're estimating that for the first 10 days of this bill cycle, you've used $50. If you continue using at the same rate you're using right now, we're estimating that your bill at the end of the 30 days is going to be $150. So it's kind of a way for you to, to better manage what your own individual energy use is, where you may say, oh, well, this is, too high for what I want my bill to be at the end of the month. So I might need to take some energy efficiency measures to kind of dial back my usage for the rest of the month. But they are estimated bill projections. It's not saying that your bill is being estimated, because your bill is being based on your actual usage and your actual meter readings. So I do understand where I think I understand that might be your confusion over some of those email bill usage
There's no
alerts.
confusion. There's no confusion. We were asking because even after adjustments had been made, that was the amount that it would come out being. But we mentioned earlier about more than one bill payment being due in a certain month, and you all elaborated on the month of June to July. I, in fact, am speaking on the month of August, where we received the disconnection notice. That's what I'm speaking on right now. That was the first bill that we received here. I'm not understanding why it didn't come through the mail, like if it was sent, but that particular bill, for instance, we had a date for August 17th, and then we had another one for September 1st, even though the $75 had been sent in. And that was done because the advisor said that there was not a generated meter amount at that time. So we're trying to figure out, or my question to you would be, in the month of August, and in speaking with Terry, there was a payment made at the beginning of the month of August, and there was another payment made, I believe, for $80. So it was $75 and it was $80 made in the month of August. That would be two different payments for that month, and I'm just using that month as one example rather than to make everyone go through the whole account from 21 to 23 to the current date. But that month alone, we made two payments, and those payments were made, and the dates that were on those due dates for those payments being made were two separate due dates and two separate amounts. For what reason? If that was the first bill. And every month we pay a bill, every month, but this is the electric company is the only utility that we've ever had to pay more than once a month. So we're just trying to figure out why the bill, instead of going down when we make these payments, is going up.
No matter what.
Do you have the Exhibit 102C available? That was the account activity statement that I referenced a little bit.
Go ahead.
Okay, so I wanted to, and first, and I think, so Mr. Pringle asked me about, like the cash concentrator payments, and your payments in 2023 were made through a cash concentrator. So I'm not sure if it's, Walmart or, the non-authorized.
Actually, Aubrey, we never ever went to a payment location. In 2023, we submit that through the United Healthcare website. I understand you all don't know the process,
Right.
but we do not go to a location to pay those bills. It is all done. It is all done. And when we did do that, that was in 22.
Well, thank you for educating me, because I didn't realize that that's how it works. So I appreciate that. But I want to start by saying, so we're looking at August of 2023, correct? That's what you're referring to. Okay. So we actually received one payment in August, and that $75 payment you talked about posted to your account on August 15th.
To what?
And then the $80 to the Waldorf account.
Uh-huh.
And then the $80, The
Can
$80
we let the
payment.
witness answer the question before another question's asked, please? Only speak one at a time.
I was just letting him know which one she said. Waldorf, he didn't hear. Go ahead.
Okay, go ahead. Sorry.
The $80 payment you referred to didn't post to the account till September 8th. So, I mean, we only received one payment posted in August and one payment posted in September. And we actually then did receive another payment posted in September of $76 on September 28th. But in August of 23, we only received one payment posted.
Okay, I made that payment while on the phone with Terry.
I got a question. So was you trying to tell us and the court that we only make a payment every 3 months with y'all? Because that's how y'all activity she's showing. But we have receipts stating payment made every month, twice a month. So that's proof right there. That's an inaccurate statement, activity sheet that you're going off of.
Have you?
Because none of our payment, none of our bills that we sent y'all is on that activity sheet. It's just ironic that every 3 months it's a lump sum that you saying that we owe y'all that y'all done already received from us. You add up them payments of money that we sent to y'all from us every 3 months, it's gonna equal up to that same amount that you saying we owe as a lump sum. It's not off no meter reading, it's off the money you receive from us. Every 3 months, 3.5 months, let's do the math. Y'all get a piece of paper out and do the math and calculate the payments that received from our confirmation receipts. Every 3.5 months, it's gonna equal up to that same amount you saying we owe y'all.
But that was
So I mean, come on, it's simple mathematics.
Aubrey, go ahead. Sorry about that. Go
No,
ahead.
that's okay. I did want to point out that I hope that we're looking at the same information because we do show very consistent payments. And that was reflected in the information we provided to staff. So, you know, if you look, you know, there are payments made nearly every month. We've never shown anything indicated that there was a 3-month time frame until maybe more recently without a payment. So we appreciate the monthly payments and thank you for that. But they are reflected in the record, so.
So on August, you made a mention earlier about August 29th, that $80 was not submitted on August 29th. Because if it was have been on the 1st or later, you just said September 8th, we would have been disconnected.
Well, I think I mentioned, though, we removed the account from threat of interruption once that informal complaint from consumer service and staff was received. So
Actually, Aubrey, Terry, who you work with us, and that recording that you have, that recording is when Terry said, if you submit this payment for this amount, then you would be able to not be disconnected. It didn't have anything to do with the informal. So I made sure that we sent in that $80, and that was done August 29th as the United Healthcare, or excuse me, as Aetna, United Healthcare, I see it, as United Healthcare reflects. August 29th, that payment was initiated. You said it wasn't received to the 8th, but it was done on the 29th. The other one was for $75 at the beginning of August as well, both through United Healthcare. I apologize that won't be into, I guess, before Tuesday, but both of those statements that I'm making is reflective in that information.
That's the reason why we didn't pay this current one right now, because we using that for our evidence.
We're just trying to show, we're trying to establish that these payments have been made. And when we received that disconnect in August, there was not a payment missed in June. There was not a payment missed in July, because in July we were told there was not a payment generated by your company at that time. You said one was initiated on July 27th, when there was a due date for July 28th. I mean, that's 24 hours. I mean, and then the disconnect that you mentioned, there was not a 21-day in between at all. That was due by August 17th, after the one from the 28th that you said had to be in. So I'm just showing that the reasoning for us filing this informal complaint is completely legit, just based on the information that you all have sent to us. So my next question, and I'll take a second after this because I know this is going to be, it says on June 30th, service was stopped. Why did you continue charges past the stop date? Why did it go through to July 6th if the service had been stopped on the 30th? Final bill or not, bill that was due on July 15th was the 108.82. We were only there 14 days of the month. Why did you all carry that bill over past the stop date to to July 6th?
And we had a new resident.
So page 89 on Exhibit 100C is a copy of your final bill for the services on Spruce. And you were only billed, if you look on the second page, so it's actually page 90, you were billed service from June 14th through June 30th. That was your final bill, and we did not bill this account in Mr. Clark's name past June 30th on Spruce.
So where did the 22nd of June through July 6th come from? Because that's what the online, using the Ameren site, that's what it shows. And it shows to this day, zero balance, last payment, 108.82, service from June 22nd to July 6th.
And if that wasn't the case, why our first bill ever at a new resident is a disconnection bill? To be our first bill ever at a new resident is a disconnection bill.
But there was no mention of $71. It stopped at the
Our
108.82.
first bill that you ever sent us at Waldorf was a disconnection bill. Disconnection. Now this is your bill for this month. It was a disconnection bill. And we weren't even at this resident less than 30 days. It's a disconnection bill. So where did you get that reading from then?
So I want to back up just a titch, if that's okay. And Miss Canada, I apologize that we weren't able to look at your exhibits yet. So whatever document that you've submitted, once I look at that, I could answer that, because you should not have received any type of documentation that indicates that we billed you for usage past June 30th.
That was our phone calls. That was the phone calls we called you for.
We'll wait
That was our
until.
question.
We'll wait until you all are able to see it. But it's from June 22nd. It states on that final account, if you were to go online through you guys' site, the Ameren site, it says zero balance, final bill, last payment, 108.82. And the dates on that is July 22nd through June 22nd. I apologize. June 22nd through July 6th. So I'm trying my best to get that over to you.
We also have another one saying a different date from June from June 24th to July 6th, July 14th.
So those are the ones that I'm so upset we can't get to you, but I just wanted that noted that is the final statement via your website. It says June 22nd to July the 6th. 108.82 last payment.
Once I see that, I'm certain I can explain that, but without looking at it, I know you understand, so thank you.
Okay. Now, last thing that I wanted to point out real quick, let me see, I want to make sure that I'm reading down what I wrote correctly. Bear with me 1 second. Cycle was created June 21st. Okay, I just bring that up. 6 days into the new service address. So is that normal? Is that normal procedures that after the customer has stopped service on a certain date that the bill would carry through to a date past that? I mean, again, we stopped on the 30th and it plainly says through July 6th. Is that normal?
It depends on, like I said, without looking at it, I really don't feel comfortable answering, but I know that it is not normal that we would notify or that we would have any documentation that says that you were billed past June 30th. That would not be normal.
So where did the amount of the 7171 come from? If in fact on the website, it does say that the last payment was 108.82.
Okay, so I'm looking at the last regular bill that you received on Spruce, which is page 85. And so at that point, your balance was 108.82.
Mm-hmm. And then as you mentioned earlier in the opening statement, it was mentioned that there was a balance of 7171 that you all applied to that bill. But when I paid that $75 in August, I was informed that that bill or that account was now closed. And and again, so I made that $75 payment just honestly on good faith because I knew there would be a bill coming and I want to make sure I stayed on top of it. But then when we received verification of you receiving that $75, it said that it was applied to a $71.71 balance of charges from the old account that was already closed. So that does need some clarification, I would say.
So we did receive the payment of 108.82 that posted to your account on July 11th. Your final bill, that I mentioned that came out for service through June 30th, the total electric charges were $90.04.
So why is
I
that?
mentioned a little bit earlier that we applied back the deposit amount that we were holding in the amount of $18.33. So we subtracted or credited that $18.33. We took that off of the $90.04 that you owed for the 14 days of service on Spruce. And that's where we got the balance of $71.71 that was still owed on Spruce. Now that balance transferred over to your Waldorf account. And when you made that $75 payment, it may have been made towards Spruce, but then that $75 payment transferred over to Waldorf and was applied at that time, but it was applied to that account number, but that account number included the transferred balance of $71.71 from the final bill on Spruce.
Actually, Aubrey, that $75 was applied to the account on Spruce that began with 504. It was not applied, and I ended up paying another $75 because of that reason to go towards the Waldorf address. But you said that you guys received that on July 11th.
But we were told that.
But we received that bill saying that you wanted 180, right? We were informed of that bill when I called and questioned about where this 154 disconnection came from. That's when we were told that there was an outstanding balance. And we did not get that bill. You all sent it via email.
And and at that time, I asked the woman, well, you said we owe you $180, but go down on the bill when it said what descriptions, it only calculated up to $90. So where the other $90 come from? You know what I'm saying?
Because now you're saying that you received that on July 11th. So that shouldn't even have been mentioned on that bill. Because it was received before you said that the bill was sent out or initiated on July 27th. So that's almost another 10 days in between you receiving the payment and when you said you initiated that bill in between what we actually received as a disconnection.
And that right there, sir, that's what I'm saying, inaccurate payments, because even on that bill, it stated $180, but go down on description and only calculate up to $90. Inaccurate payments.
So we're just trying to follow along.
Oh, man.
I'm not sure. I don't know what the question is at this point.
The question is, you're saying to us on this conversation or during this hearing today, you're naming these dates and these times, and we're listening. Obviously, we're listening. But if you're saying that something was initiated on the 27th, but you received this on the 11th, but on this bill that we never received, until we got the one that was due August 17th for 154 and a disconnect amount. When we inquired about that, we received an email showing this 180, but it was, we didn't receive the payment before we sent out that payment. But you just said earlier that you received it July 11th and initiated that on July 27th. So
Let's keep it simple. Can you explain to us all the payments that we get sent to y'all, where they apply towards? Go one by one. All the payments that we sent to y'all, tell us what bill did they go towards, and how we owe y'all.
And we're speaking from 2023 to end up owing this money after we stopped the service.
No, because we owe that money. We owe this same money from the very first time this account opened, from last year, from the year before that, all the way up to this point, around the same time. Explain to us all the money that we sent to y'all, where did they get applied towards?
Any
I don't got nothing to listen to, man.
Yeah, the Exhibit 101C that we presented, which shows the payment history, it breaks it shows you, page 1 shows you the payments that were applied to the Spruce account in 2003. Of course, it goes back to 21. And then on page 2, it shows the payments that were applied to the Waldorf account.
Okay.
So that's where the payments. So if you have, and maybe I should put this out there too, if you, when looking at this exhibit, see any, if you believe that you made payments that we did not apply,
you said it.
Better.
Yeah. So.
Go ahead. I'm listening.
So I guess I will be interested to see the information that that you have for exhibits to ensure that, and I guess I'm not sure what payments you have made that you believe have not been applied to your accounts appropriately.
Well, I'm particularly wondering on the activity sheet why when we do make these overpayments, because the whole purpose, Aubrey, was to be able to use those funds if necessary when we did move. So where are the credits being shown on the activity sheet?
So we get this evidence to them, man. They already got it.
Because I don't see on the activity sheet anywhere where it shows a credited amount in the amount of $29.45 or a credited amount in $18.33 or credited amount in $10 or $1.90. I'm not seeing any of that on the activity sheets that you all are using. They don't show it.
I think I understand what you're asking. So I'm looking at Exhibit 102C, which is the account activity statement for both of the accounts.
Yeah.
And there is not a specific column that shows any overpayment amount. However, you have to kind of calculate it manually. So let's just go back to, we'll say, so April 6th, March 22nd of 2023, this is page 3 or 4 on Exhibit 102C. Your bill amount came out for $89.20.
Mm-hmm.
We received a payment on April 6th of $100. So without getting my calculator out, that's about $11 of an excess credit that you had at that point in time.
Right. We're just asking why you all don't show them.
It doesn't show on this activity statement, but you can see then your bill came out on April 21st for $104.06.
Mm-hmm.
That was the amount of your total charges, but your total bill was only $93.26. That's where you can see that the credit was reflected because you had an overpayment, you had a credit amount, it was applied to the $104.06, which left that total bill amount of only $93.26. So even though there's not a specific column that reflects that you overpaid by $11 and some change, it is reflected in the amount of your total bills each month.
So when a customer overpays their account And even though it's not reflecting on the activity sheet, and we do get the emails and the text saying you have a credited amount of this amount or that amount, what I'm wondering is, do you feel, or I guess your opinion shouldn't be, but shouldn't there be a way where the customer can say, well, I would like to use my credit for this or that? Because an advisor simply said, well, you didn't tell us within the time frame. And when we asked the time frame, they weren't able to give us one. So isn't that something that the customer should be able to do as well? Be able to say, well, I overpaid this and I would like to apply it to this without it just being gone?
Sure, I can answer that. And I do want to start by saying on your bill statements, not any of the email alerts that you're receiving, but your actual copy of the bill. Every month when you had an overpayment, it does show that, even though it shows like I'm looking
charges.
right, but it shows credit and then a little negative 1080. So you overpaid by $10.80 the previous month, for example. Now, as far as overpayment of an account, so if your balance for a month is $100, you pay $150, you have a $50 credit. That credit is not going to automatically be issued as a refund check to the customer. It's going to sit there as a credit, and then it's going to be applied to the next monthly bill. Unless for some reason if a customer calls and said, hey, I paid extra I paid $50 extra this month. I would like this $50 to be applied to another of my accounts, or there were some other scenarios.
How much time does the customer have to do that?
Not a whole lot, to be quite honest.
Because we were told, exactly.
Sure. So, but you definitely get the benefit of that credit or that overpayment because it is applied to your next month's bill. However, there's also, we have a certain overpayment refund process that is an internal process or policy that we follow. And generally speaking, a customer refund is not issued in the form of a check unless a customer asks. And then there are sometimes we might ask the customer to mail in a copy, a bank statement, stating such. I mean, there's a lot of different variables in there, but a short answer is no, it's not going to be automatically refunded to you.
Okay, because I'm glad you said that. That was my last question, honestly. That is exactly what I was about to say. Now, the way that I found out about this around the clock billing and the peak time and the day and night, this was not information that was given to me by any representative. My sister, my blood sister, is an ex-corporate Ameren employee. Her name is Tamika Cole. I have no reason to lie about this. That is how I found out about there being payment plans. Now, again, you keep saying that they could see it on the website, but some of us don't have the ability to see. So with that being said, the advisors should be saying this and this is available, but since they didn't, that's never mind. My question is to you at this point, what exactly has been the training procedure, or what exactly do you all do when a customer asks, I would like that in the form of a check, and the advisor tells them, we do not do that? Now, you said that there's extenuating circumstances, but if you listen to our recordings, Aubrey, you know that Mr. Clark asked several times to have his credited amount, whether it was $20 or $2, to become a form of a check, and he was denied that ability.
Sure it was, most of the time.
Why is that if that's an option?
Well, without listening to and reviewing the specific, if you knew it a specific interaction, I certainly could look at that.
All 40 of them.
It should have been more than that because we got more.
40, exactly, and that's why it's hard for me to reference a specific call since I did listen to so many of them. But I will say that oftentimes it may have been based on the timing that your account was already in the bill cycle window. So I really can't answer that specifically as to why, on what specific occasion Mr. Clark was advised that we would not send a refund check. But chances are, I mean, it was applied to the next, I mean,
Well,
not
I
chances.
would like
was
it to be notated that we did request on more than one occasion for that to be sent back in the form of the check. And we did stop doing the overpayments upon coming to the ward off location because we were told we don't do that. So I just wanted that to be noted, that even though you say that there are situations where you all do that as the customer, we were denied not once, not twice, but at least 3 times of receiving a check for our credited amount. I just want that noted.
And I want to be
Okay.
noted that
I think it's a good time to take a recess.
Yeah.
When would everyone like to come back? Is
When we talk about some
1:45
recess, I got to ask.
is 1:45 too soon?
1:45. It's 1 o'clock.
It's 1 o'clock.
And we do 2.
Is everyone okay with recessing until 2?
Because my cousin finna come down here and help me submit our evidence for us.
Okay.
So, you know.
We will recess until 2. I'll see y'all then. We'll go off the record.
Thank you, Judge.
Your Honor.
We can go back on the record.
I'm here.
Okay. Ms.
Is
Kirschner?
the judge on the line?
Yes, I'm here.
Okay, I apologize. Mr. Clark just got called to an emergency with his daughter at school. He had to step out. I'm not sure what that's gonna mean into regard of the rest of the hearing, but I am still available. I just wanted to make sure that you knew. He
I
had to step
appreciate
out.
that. I hope everything's okay with his daughter. Because he's not testifying, and I don't think we anticipate him testifying anymore, I don't believe he needs to be here. If he wanted to cross and have any questions for witnesses, then that would be the only purpose for him to be here at this time. He is a party, but
Yeah.
I think because you're
He-
jointly.
Yeah, he said he did have some stuff that he wanted to speak on, but he was afraid he wouldn't make it back in time. So we could just move forward if you want, and if he makes it, he makes it. I'll try to cover anything that he wanted to bring up.
Okay, I appreciate that. And I believe, are we on the record? Is that yes?
Are you talking to me?
Yes, sorry. Ms. Blesky?
Yes, we're on the record.
Okay, thank you. I believe you were still questioning Ms. Kirschmer, Ms. Canada. You may continue.
Judge, this is
Yes.
Travis Pringle from staff. Just one matter before we proceed. I did receive
sir.
an email from Ms. Canada with it's titled evidence for hearing.
Yeah.
Would you like me to forward this on to the parties? It has 4 attachments to it.
Yes, if you can, Mr. Pringle.
All right.
Yeah, and as far as that's concerned, Your Honor, as well, we're still trying to get the rest of it over to you. I think that the problem was he was trying to send it to too many people at one time. So we have my one of my family members over here trying to get the information to you all. So it might come through a little at a time as we move forward.
Okay.
Yeah, and Judge and Jennifer, I'm sending the email right now with those 4 attachments from Ms. Canada to, so you guys should have that shortly.
All right, thank you.
Okay. Alrighty, so let me pick up from where I was. All right. Arbery, how do I say your last name? I don't want to murder it.
Oh, that's okay. It's Kirschmar.
Kirschmeyer. Okay. So, Ms. Kirschmeyer, what I am going forward with, I'm hoping I'm not repeating, but I tried to stop and mark where we were. Oh, hold on 1 second. I'm sorry. Okay, hold on.
Send you stuff, I send other stuff.
Okay.
Once they're voted up on her, she'll press send.
Okay. Okay. Is there any way you could just wait until, because I have to move forward once it loads, is it going to take a while? Okay, thank you. All right. So he just let me know that we got a little bit of it worked out. Unfortunately, we're still having some issues with the remainder of it. So if that still stands until Tuesday, I would get that over to you all. I'm sorry, I'm getting a little bit overwhelmed with this whole situation at this point. So, okay, moving forward, you had mentioned that you all don't consider the CPAP machine a life-threatening medical equipment. You remember saying that earlier?
Yes, to the best of my knowledge, I'm not an expert on the medical equipment registry that's handled by a specialized team within the company, but to my recollection, a CPAP is not considered critical medical equipment.
Okay. Well, the reason that I'm acting on that is it's not often that people would take their CPAP, out on the road unless they're traveling out of town. But you had mentioned that we did not get the medical review forms back to you in time, that they expired. So when that happens, do you not initiate another one going out immediately, or do you wait to see if we request another one?
Well, the medical equipment registry, the pending status does not expire until after we send a notification letting you know that we're still waiting on it. So we do send notification, but once it expires, there is not an automatic mail out of additional forms. That's correct,
Right.
unless the customer calls back and requests it again.
Okay. Just wanted to make sure. Okay, so, gotta go back a little bit. Now, another example that we were speaking on was in June of 2022. He was bringing up how some of these payments are the multiple payments in 1 month does repeat. In the month of June of 2022, there was a payment made on the 1st, and there was another one made towards the end of the month. Again, because of the threat of disconnect, we have been making payments every month since the account has been open. Recently, we were informed about a 50% payment that has to at least be paid on the accounts to not go into disconnect status. I'm assuming that's what they meant, or that's what they were trying to explain to us. But with that being said, that was our example, or one of our examples of this reoccurring. So when we go back and look at the March of 2022 disconnect, where you said the error occurred in your system, would that not be something that you would call back and let the customer know that there was something done in error when in regards of a disconnection, because we were disconnected, reconnected, and then disconnected again, and then reconnected? So we're just trying to find out, is that where the payment issues started to become overlapping, or is that where you would say the account began to get a little out of whack, for lack of a better word?
Well, I'm not certain I understand the question, but to be clear, the system issue that I described earlier when Mr. Pringle was asking for clarification, that did not have anything to do with payments posting. It had to do with the fact that a second 96-hour outbound collection call attempt was not made prior to an interruption of service during cold weather rule. So that had nothing to do with any payment postings. So that wouldn't have affected anything.
Well, what I'm getting at is, without us being aware of the registry for the cold weather rule, for us to have to take these steps, we just assumed, and I guess we shouldn't have just assumed, that the cold weather rule pertained to everyone. So upon that disconnection, why was it not explained to us at all that that was the situation at that initial time, regardless of, the call that came in? But during that cold weather season from November 1st to March 31st, when that disconnect took place, why weren't we informed at that point about the cold weather rule or the registry for it?
Well, I think I may have mentioned this earlier, but we did not receive any contact from you or Mr. Clark prior to your disconnection for non-payment on March 4th. So we had no contact with you. So therefore there was no discussion about your opportunity for a cold weather rule payment agreement or energy assistance, or even the caring contact program. And I think I mentioned this as well earlier, that the registry, the cold weather rule low income elderly disabled registry, which we consider as part of our caring contact program, does not prevent disconnection in cold weather rule. It just allows for additional notifications and or potential payment options that might not be available to those not in the caring contact program. But again, you didn't call us prior to the disconnection you didn't call us until March 4th. So we had no opportunity to discuss anything related to the cold weather rule with you or Mr. Clark.
What I'm asking is, when we made that call on March 4th, why were we not informed at that time the advisor did not say, hey, there's a registry for it. Why were we not informed when we were on the phone, when we were being disconnected? Why were we still not informed about it? It didn't end until the 31st.
Well, there was no mention on the March, I listened to the calls that were made on March 4th. I actually re-listened to those again this morning. There was no mention, the discussion between you and our advisors only had to do with the reconnection, what was needed for reconnection. There was no mention of a request for a registry. There was no mention of
I'm
income
asking why.
disability. So there was no indicator that you were interested in seeking that. And
well, we were we were disconnected and reconnected. I'm asking why is the advisor not saying at that time to us? We had no knowledge of it. I honestly did not find out about the cold weather rule until I spoke to Ms. Fontaine once we had started this whole process. I'm simply asking, upon that conversation, I know it wasn't mentioned because we didn't know about it. I'm asking, why were we not informed about it by the advisor at that time?
Well, let me back up just a little bit as well. So you actually had already been on a cold weather rule payment agreement in 2002's cold weather rule season. In January of 2022, you established a cold weather rule payment agreement, and I believe you did it yourself through our voice response unit. There was no contact made with an advisor in January of 2022 when you set up the cold weather rule payment agreement, but you had already been on a cold weather rule payment agreement, which defaulted due to a missed or partial payment. That defaulted in February. So
go ahead.
So when after your services were disconnected, and you were calling in to see about that, you were offered a reinstatement of your cold weather rule payment agreement, which is what we do during cold weather rule. We don't offer you a brand new one. We offer to reinstate your existing or your previous cold weather rule payment agreement. So that option was what was available to you at the time. But again, the registry at that point would not be something that the advisor would think that would be beneficial to you because your services had already been disconnected. So it really wouldn't make the most, it wouldn't be an option that I think the advisor would seek to provide you information for due to the timing of that call after disconnection on March 4th when the cold weather rule is scheduled to end March 31st.
I think that any information, anything that the advisors have knowledge of at all should be informed to the customer, whether we know about it, whether it's pertinent or not. This is information that, is almost it's basically what you're saying is don't ask, don't tell. I mean, if we don't know, I thought I was just under a regular payment agreement, for instance. I didn't know I was under a cold weather payment agreement. Do you see what I'm saying? So I just don't understand why the advisors aren't informing us all of the information, whether the customer knows about it or not. A monthly bill, let's see. Okay, it says Chapter 13, Service and Billing Practices. I believe that it was either number 7 on that? It says a monthly bill customers should have at least 21 days from the condition of from receiving notice via bill to pay the utility charges. Now, I'm going over that statement just to bring up the transfer of service or the stop service. Upon ending the prior accounts and starting the new account, what happened to that rule? Because we received, again, no bill for the month of July. The first bill we got was a disconnection bill. We did not receive any notice of a disconnection bill. We did not get notified that we were in disconnect status. The first thing we received was not a green copy, was a red copy, disconnection charges. Why was that done that way?
Well, we did send you, apparently you must not have received it, but we did generate a bill for service on July 26th of 2023. That was your first bill for services on Waldorf. This was generated on July 26th with a due date of August 17th. Since payment was not received by August 17th, that disconnection notice, which you, it's, in my opinion, you believe was your first bill. It wasn't an actual bill, but that disconnection notice was then generated and mailed on August 22nd, since the August 17th due date for services was, there wasn't a payment received by then. So we did, we did mail a bill prior to the disconnection notice for service on Waldorf.
Okay, I'm gonna go back to that bill. Here we go, right here. Because this bill states final notice, does it not?
That's not a bill, Miss Canada. That is a disconnection notice. So there's a difference between a disconnection notice and an actual bill statement or energy statement.
So you said that you guys generated one on the 26th that we obviously did not receive, but that's neither here or there. What I'm saying is this one right here that says final notice, the disconnection statement that you're calling it, was there any notice in between those two, the one you said you sent out or was generated on the 26th and this one, and it says the due date on this, if I'm looking at it correctly, it says August 22nd due date, or is that?
That's the date it was made.
Okay, so if you're saying that that was sent out on the 17th, September 1st was the disconnect date, that sounds like less than 21 days.
Well, we're required to provide 10 days notice before disconnection for non-payment. And this is, like I said, this is not an actual bill. The bill that was generated July 26th had a due date of August 17th. So that was the regular bill. Since payment wasn't received by August 17th, on August 22nd, a disconnection notice was rendered. And
So
that allows 10 days, and of course, September 1st, subject to disconnect after September 1st. So the soonest that the account would have been subject to disconnection, based on what I'm looking at here, would have been September 2nd, which is the 10 days.
Okay, it says amount and date of last payment, $75 received on August 15th. Again, I don't want to go back and forth about if we received it or didn't receive the first one, but there was a payment received on August 15th itself. And then you said that the next payment for $80 you all didn't receive until September the 8th. However, that was done on the 29th, and that was the day of the conversation, I believe, with Terry to find out, and we were already in the formal process. That's why we were actually talking to Terry at that time, and she informed me of what I could do, how much I could pay to stay connected, and that's why the payment of $80 was submitted. So again, the 21 days I'm not seeing from the date you received the last payment, and you said that was due on the 17th to September 1st.
Well, again, I don't want to keep repeating myself, but
We'll just leave it at that.
Okay.
Then. It's fine. It's not 21 days. Okay. So the last question that we have, or the one question that Dranel wanted me to make sure that I mentioned to you all, is what was the explanation for this one thing? Why, when we make our payments, is the bill increasing instead of decreasing?
well, as the account activity statement reflects, your payments are being appropriately applied. The payments then will decrease the amount that was
Ms.
due.
Kirschmar, I just want to interrupt real quick. This is Exhibit 102C, correct? That
Yes.
you're referring to?
Yes, I'm sorry. Yes.
That's good.
Yes. So you're still billed for actual usage each month, of course. So there's a column where you're receiving credit for your payments. And then the column where you're receiving a charge or a debit for the electric service that's used in the next billing period. So your balance is decreasing by the total of the payment that you've made. But then, of course, with the next monthly bill cycle, you're then billed for additional electric service used.
So every time that we paid our bill on that activity statement, you're saying that you receive it after the other bill has been initiated, and that's why it looks like it's increasing?
Probably not every time, but sometimes, certainly.
And the due date on the account when we were on Spruce, I believe, was the 15th, correct?
On Spruce, I'm just glancing at Exhibit 102C, even just the first page. It looks like, yes, at the end of the account, once the account was closed, looks like the 15th of almost every month. Because of course it can fluctuate by a day or two, but yes, it looks like when you closed out the account there, the bill due date was on the 15th.
Okay, I just wanted to make sure that was the correct date. So the payments that you receive before the 15th, if that's the due date, you're saying that even though you received it before that date, it's still going to generate and go up regardless on the next column. It's still going to increase, even if it was received before that date. Am I understanding it correctly?
Well, I'm not sure that I'm understanding your question correctly, so I don't want to misspeak.
Okay. Let me see how can I say it. Let's go back. So what was that when you guys had it as? I'm sorry,
102C.
102C. So I can pull it up so I can clarify myself better. I don't want to confuse everyone, and if I'm misreading it, please correct me. But so what I'm seeing on 102C right here. Okay. So when I look at it, I'm gonna pull randomly one of them, if that's okay with you, as it is really, really small. So I'm looking at these dates. So transaction dates, right? What exactly does that transaction date mean? Is that the date that you all initiated it or sent it out? Or is
that would be the date that the transaction occurred.
Okay. So the dates on those, I'm looking at the 14th, the 11th, 13th, 12th, 9th. I see some that are like the 20th and the 22nd. Those were early in 22 and 21. So I'm just looking over this, but I'm not seeing right here where it says billing period. For instance, the very first one from September 1st, 21 to September 11th of 21. And then September 11th of 21 to the 12th of 21. Now that would be a full month. But then when you scroll down some, the dates, they don't just stay at the 1 month. The transaction date is the, for instance, in May of 22 is the 19th. And it says that the payment was for the 14th of April through the 14th of May. You received the payment. And then what I'm saying is, so you're telling me that when you receive that payment, it would be added to the next, I guess, month if you didn't receive it in what amount of time? I'm trying to understand how they're on my end, even though I know I'm paying this bill, how it's reflecting as an increase rather than a decrease. I'm trying to follow you on that, but it's just not making sense to me. I'm not gonna lie to you. I'm really, really confused.
And I understand that, I certainly can see where the statement can be, confusing. I, of course, I've been reviewing these for over 20 years, so it's
Right,
easier for me.
right.
So I definitely understand that. So your payment credit, so I'm trying to decide how would be the best way to explain this to you. So the payment credit in that column, that is the amount of a payment or other sort of credit that came in. And then you would scroll over to the transaction date, and that's the date that it posted to the account. So, and was therefore subtracted from the balance due. And that would then reflect on, if you go down to the line underneath it, then that would show your next bill amount for regular service, electric service. You can, if you take that, whatever that balance was, you almost have to start at the top. And here was the first bill amount. And then you go down to the next row and add in any charges. That's going to get you to the total bill amount. And then if you go down to the next row, if there was a payment, you'll subtract that payment and then add in any charges like the late payment charge, deposit, electric service. And then that's going to equal what the total bill was for the next month. And you kind of have to go down and subtract your payments that way.
Mm-hmm. So let's start right here at the very top where the September of 21 when we first started at. Okay, I'm seeing charges and debits $47.85. That was our credited amount because I remember we paid $100 to start this account.
No.
Is that correct?
It's not. So September 14, 21, that was the first date that the first bill that was generated here on Spruce. So you were billed a deposit and it was broken into monthly installments of $17.67. So on September 14th, when the system was was generating the bill, you were charged $17.67 for a deposit installment and $47.85 for the electric service from 9/1 through 9/11 of 21. So those two added together equals the total bill amount, regular bill of $65.52,
Okay.
which has a due date of October 6th.
Okay.
So there wasn't a payment received on that bill before the next row says on October 11th of 21, since there hadn't been a payment received by the October 6th due date, there was a late payment charge added. And then on October 13th of 21, a bill was generated. So you were billed the second deposit installment of 17 and some change, and then your electric service from September 11th through October 12th of $119.22. So you add the $65.52, which was the prior balance, plus that late charge to the new charges for October 13th. And that's where you get the total bill amount of $203.16, which was due November 4th.
Okay. So then, with that being said, from the very beginning, it sounds like what you're saying is that you were receiving these payments after the date that they were supposed to be in, and that's what I'm getting from that, right?
Yes, ma'am. Because then if you go down one more row down, on October 18th of 21, we received a payment for $65.52. But you can see that was for the total bill of $65.52, which was due on October 6th. And we didn't receive it on October 6th. We did not receive that payment posted until October 18th. So it was after your October 13th bill had already generated.
Okay.
But we still gave you credit for it, of course.
Right.
So then that was subtracted from the 203.16 and then kind of moving. So yes, we were receiving payments initially for sure. When the Spruce account was opened, you can see there were not consistent on time in full payments each month, which is why there was a balance that kept carrying over from month to month.
Right. Okay. So then we did the informal complaint the first time and received the pledge to get that balance down. So now I'm looking at 2023, and this is when the insurance company is now doing the third-party payments at that point. So I'm looking at the previous balance column, and I'm going from February 15th is the due date. Am I reading it right? Is that what you're seeing?
Yes, 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 yes. On page 3 of this exhibit 102C, right?
Right. And that's the issue. Usually my eyes will double the numbers. So I'm just making sure I'm looking at the right numbers. So after that, the due date is the 15th every month, right?
For the
then-
rest of that time, yes, absolutely. Yep.
Okay, and then we get down here to where we're having the issue. And this is where we stop doing the overpayments in June. So I see the 108.82 right there. And that was due on July 15th. You're saying that there was a final bill generated. The online account stated that the 108.82 is the final bill. And then you mentioned earlier something about a transfer over for the $71 remaining balance, right? But I don't see that. And so I look at the very bottom here and it's under the new account. But if the account was, if this was a final bill or whatever you're saying that this was, and then I see the $18.33 that you guys have under the additional charges area at that time as a deposit, which took it down to $71.71. Why is it that when we paid that initial $75, we were told that that was on the Waldorf account instead of the Spruce account? It wasn't until later when I called and was told that that was applied to a Spruce final payment. But online, it says from you all, June 22nd to July 6th, 108.82 last payment. I'm just trying to understand why that is. And we did request anything left over by check. We were told it wasn't done, but then we get this 71.71 after.
Okay. Well, let me try to explain this to you. So that third column on the bottom, or third from the bottom column on page 304. So as you mentioned, you knew that 108.82 was your amount due July 15th.
Mm-hmm.
But then if you scroll to the left, the billing period, that only took you through June 14th. So service through June 14th on Spruce, there was an amount due of 108.82. Well, you can see it wasn't due till July 15th. However, when you closed out that account, we had to render a final bill, which you see on July 6th, it says bill final instead of regular bill. We had to generate that final bill for the service from June 14th to June 30th. That bill wasn't due till July 28th, but you see the 108.82 wasn't even due yet. It wasn't even due yet.
That's what I was saying. That's where I feel like the issue is, because you're saying a final bill was generated. If we weren't there for the entire month, the bill wasn't due until the 15th of July. Why was there a date past the 30th? Why did it go through July 6th period? Like, that's not even making sense to me for it to go to July 6th.
And and that's why once I see what you're referring to, because I am interested to see what you saw online that told you that we billed you through July 6th, because we didn't. We only billed you through June 30th. And if I'm able to look at what you're looking at, I might be able to better explain it. But right now, I can't see.
I think that's one of the ones that it just keeps saying queued on. It's not letting me send that one through. So, okay. Well, then at this time, I'm done as far as my questioning. I know Mr. Clark has some other ones, but that was the only one that I could remember.
Okay. Are there any questions from the commission? Hearing none, I have a few questions. I guess to kind of stay on the topic, had Mr. Clark and Ms. Canada remained at the address, the Spruce address, into further into the month of July, would that bill have generated and been due for the 15th of August rather than the 28th of July? Is that why it was due on the 28th, is because they left on the 30th of June?
Yes, Jeff.
Okay.
Yes.
And I'm going to kind of change topics now. If we can look back at 100C, the billing statement, really any of them, I want to refer to the blue area and the electric service details. When it has the phrase for the reading type, you had said that actual means that's the real. What other things could come up in that area than actual?
Actual or estimated.
Okay. And
Those are the two reading types. Oops, sorry.
And for the usage type, is that's the type of, it says on peak. Is that available to customers on their bill consistently?
The usage amount, yes, that displays on every monthly bill statement. And so since this account was on evening morning savers, it splits it into, it provides the differences. And I do want to make a point that, like the beginning bill statements that we presented as part of this exhibit, in 2021, there are differences. We are continually looking for ways to improve our communication and our bill statements to make things easier on customers. So you may see differences in this September 21 bill format as opposed to like the last bill in that exhibit. So I just wanted to kind of point that out too.
Okay.
Why do we have more bills? Oh, I'm sorry, Your Honor. I'm sorry.
You're okay. We'll have another recross after my questions. Referring to what Mr. Pringle sent us earlier, I had a question about that, if I can pull it up.
And Judge, one more, I just got another email from Ms. Canada, Mr. Park, with more recordings and PDFs I can also forward to the parties.
Yeah, if you can. I may recall Miss Canada to offer her exhibits.
Okay, thank you.
So on the data request 13, I don't know if you have that available to you, Ms. Kirschmeyer.
Jennifer's going to pull it up for me. Yes.
Okay. I just have a question in it because it states at one point that the accounts will not be billed for a reconnection fee regarding that missed 96-hour call attempt. Referring to that and the billing statements, I didn't see in that bill that there was a reconnection fee, but it looks like in staff's appendix they have a reconnection fee listed in March. Was there a reconnection fee? Are you aware of one for Ms. Canada and Mr. Clark in March of 2022?
Yes, the account was billed a reconnection fee. The information that we provided to staff in March of 2022, which were the ways that we were rectifying the issue, we actually reached out to customers that hadn't received the notification whose service was still off. And reconnections were issued to those customers as of, I think it was March 8th, that were still off. And those accounts were not billed a reconnection fee. So this account was billed a reconnection fee.
Okay.
So,
thank you for that clarification. What's Ameren's policy for notifying customers about the different rate types? Is that something that, sorry, to clarify, is that something that the customer has to request, or is that something that the company provides to the customers without requiring a request?
So there is different communication, and I guess there are different scenarios since we're still have our AMI or our smart meter implementation ongoing. So we do send communication to customers once they've received, once they've had a smart meter or AMI meter installed. We send communication to customers in advance of the So the SIP and agreement, once the AMI meter is installed, they are defaulted to the evening morning savers TOU rate 6 months after installation. So in that 6 month from the time the meter was installed until they've had it for 6 months, we send several pieces of communication which explain the evening morning savers rate is coming to you. This is going to be defaulted to you in 6 months, but you do have the choice to stay on the anytime savers or anytime users rate if you'd like to. They have an opportunity to mail in a postage paid postcard, or they can call, or they can go online. They can actually even do it through our voice response unit, through our, the phone system. So, so the written communication goes out. We also, when customers, like with the, for this specific customer, when you move into an address where they have an AMI meter already and you're just going to start out at the evening morning savers rate, there is scripting that is suggested that our advisors are trained to make note of it. You are going to be, your service will be starting on September 1st, and you will be on our evening morning savers rate. We do have other rate options available to you, and you can go to our website to find out more. And then that gives the customer an opportunity to do the research on their own instead of being shared detailed information about every rate that we offer to a customer, which some customers may not want to, take the extra 5, 6, 7 minutes on a phone call when they're trying to set up service, for us to go through in detail all of the rate options. So we make mention of it and generally explain to the customers that we can send you a brochure if they ask more. You can go to the website to find out more, but we are always trying to balance the length of a call, how much time a customer is on the phone with us to do a transaction with the information that we have available to them. So if a customer asks, we are going to take as much time as we can to share all of the information. But if there's not really an inquiry from the customer, we may just kind of tell them where they can find it on their own after the call, if that makes sense.
Sure. Thank you. And it seemed like for the cold weather rule and the medical equipment registry, those do need to be prompted. Is that the case, or is that something that's also even mentioned somewhat in passing on a phone call? Or is that something that like a buzzword or something would lead to?
Sure. So generally speaking, we do hope that all of our advisors, and I think they do a good job of being, intuitive to a certain degree. So if certain, things are mentioned, if a customer, has mentioned that they have medical equipment that they really need service for, that would be a good opportunity for us to explain the medical equipment registry and offer to share paperwork so that the customer could, potentially enroll in that. And it's the same thing with any of our other options, whether it be the Caring Contact program or the many energy assistance options that we have available to share information with for customers. It is our intention that advisors are intuitive and will, depending on how the call goes and what's mentioned by the customer, will offer the appropriate program information to them. So.
Okay. And I think the last question I have, would it be possible for Ameren to send out a notice on a bill or a separate leaflet or email, what have you, to a customer prior to November regarding the cold weather rule? And
Honestly, Judge,
what could prevent that?
I think we do that right now, but I'm going off of memory without looking it up. But I actually think that we do send out a specific once a year energy assistance options prior to cold weather rule, but I'm not 100% certain. I'm going off of my memory right now, but yes, it would be possible. And I think that is something that we currently do, but I'm definitely going to check into it after today.
Sure. Okay, that was all of my questions. Is there any recross by staff?
No recross from staff, Judge. Thank you.
Okay, and recross from Ms. Canada or Mr. Clark?
Yes. I just wanted to know, why do we have more bills than we do months of the year, or each of the years that we've had this account open? Whether, because you're saying that these are disconnection statements, not necessarily bills. So I was just sitting here kind of going through them during our recess, and they're adding up to be more than 12. That's the only utility, electricity, that I'm finding that happening in. Is there a reason for that?
Based on the information that I'm looking at, we have only sent you, for the most part, unless there was a partial bill where you transferred service, but we do only send one billing statement per 30-day bill cycle. So it, like I said, depending on if there was a prorated bill, if you transferred service, so that likely occurred.
Okay.
At least, you know, when you transferred from Spruce to Waldorf.
Yeah, okay. It was before then too, but all right. There was something that the judge just mentioned that kind of buzzed in my ear. So that's what it was. He was asking about sending the customers the information about the cold weather rule, and then you went into mentioning the assistance program. What does Ameren do upon this situation that, you know, these assistance programs that you're referring people to are out of funds? That has happened to me several times. I mean, like right now, the LAHEAP program, you know, I've signed up for it, and I'm told the process is 60 days, but you can't start it without a disconnection notice, you know, but now the funds are being exhausted. The Urban League is out, Community Action is out. This is something that happens a lot to people in my situation. So what does Ameren do to help? Because I did not know about any of the other programs, again, until I started really researching the company. So if I wouldn't have done that, I wouldn't have known about a clean slate program. I wouldn't have known about the 50% during the cooling months. There's just so much information that you've made mention that you guys do have available to your customers. But again, it almost seems like don't ask, don't tell. I mean, not to assume that you're offending anyone. There's nothing wrong with simply saying, you know, does this apply to you? Especially if it can help, or if you're noticing over the time of the account that there's a reoccurring issue with that customer. I mean, what do you all do in those situations? We just have to be cut off and that's it? Oh, well.
From my experience and the many calls that I've listened to, I do think that it is a priority of our employees to provide all of the information. I do know that sometimes that agencies are out of funds, but we have listings of energy assistance agencies that we provide. And as a matter of fact, it's on every one of your disconnection notices, which is unique to you as well. So I'm looking at just your notice from Exhibit 105C. On the back side, there's not just some of the agencies that have like that government funds, but you know, we give you numbers to your local Salvation Army. We tell you about the United Way 211, where you can either call or go online, and they may have, you know, United Way may be able to put you in touch with local community agencies as well that may have funds, or even local churches. So
that's exactly what I'm speaking on, Aubrey. I mean, I'm not going to pretend that I'm in a financial situation that I'm not. I utilize any assistance. United Way and 211, yes, they will give me a number, but when I call that number, if that particular church or community outreach program is out of funding, and then I call back the utility company and say, hey, I took the numbers that this person gave me, this person gave me. I mean, I just went through this not too long ago with water. I'm saying that, what do you all do in that situation where the funds just aren't there? Or, you know, you call these numbers from United Way or 211 or even your program, and they say, well, did you try this person? They give you another number to call and another number, and then you end up circling right back around at a lot more situations than not. and you have to say they're not there, the funds aren't there. Now you're sitting there crying your eyes out trying to figure out how you're going to explain to your family that we don't have electricity, for example. So I'm just saying, what is Ameren doing in those situations? Are you all actually calling United Way and saying to them, hey, are there any funds out there? Because we're referring these people, but they're saying that they called the numbers that you gave them and there's no funds available. What are you all doing to help us?
Well, and I definitely, I mean, I certainly understand that those are hard situations to be in, but we, you know, if a customer is not able to obtain energy assistance, I mean, we also have payment options, which we outline on the disconnection notices and should be advised by our employees as well. You know, there are oftentimes opportunities for a payment agreement or even a payment date extension. We don't offer, which will give you a little extra time. So maybe, you know, you're going to have a payment coming in later in the week, but your disconnection is scheduled for Monday. We can, you know, oftentimes offer you just a couple of extra days, an extension to pay that bill if you're not able to, you know, obtain energy assistance funding and you need some extra time until you actually get paid. So we do have other options available other than just directing customers to try to apply for energy assistance.
Okay. Okay. I'm just asking because I know for a fact that happens more than it doesn't. And then when we make these arrangements that you're speaking of, or take the extension, as the activity sheet just showed, it's rolling right over, and now we get a bill saying that it's gone up rather than gone down, and we set up an extension. I mean, shouldn't the activity sheet have a spot on there to say extension given, and that way when the next bill comes out, you're not sitting there like, oh, they want $300 and something from me, but I thought I had until this date to get it into them. I mean, these are just things that I have observed as a customer that are very frustrating and concerning. And I feel like sometimes these are things that people overlook when they're not in that situation themselves. So that's why I'm asking the questions that I'm asking, because this is the type of stuff, since this account has been open, that has happened. I mean, we took a pledge via Terry's advice in 22 and turn around the very next month, the bill is $167. And that was January of 2023. So it's seeming like, you know, the assistance is set up, but the assistance that is given, you get hit with another one before that even goes through. Or then when you call and say, you know, what's my balance? There's nothing there. And then you get a bill the very next week saying this or that. So that's why I'm asking the questions that I'm asking. I know you have the program set up, but if they're not working, what are you guys going to do if the programs aren't, if it's not working? And I know I'm not the only one because I've discussed it with other people. That's why I'm asking the questions that I'm asking. So, moving forward though, I don't think that I, again, had any further questions. I do know that Dranel had a list of his own, so I apologize that he's not with us.
Okay. Redirect from Ameren.
No questions. Thank you.
Okay. Ms. Kirschmar, you are relieved. And now we can move to staff. You can call your first witness.
Thank you, Judge. Staff calls Ms. Sarah Fontaine to the stand.
Okay, Ms. Fontaine, can you raise your right hand? Do you solemnly swear to tell the truth in this testimony?
I do.
Thank you. You may proceed, counsel.
Thank you, Judge. Good afternoon, Ms. Fontaine.
Good afternoon.
Could you please spell and state and spell your name for the record?
It's Sarah Fontaine. It's Sarah. Last name is Fontaine.
Thank you, Ms. Fontaine. And by whom are you employed and in what capacity?
I'm employed by the Missouri Public Service Commission, and I am a senior research data analyst.
And are you the same Sarah Fontaine who contributed to staff's report in this matter, which has been pre-marked Exhibit 200?
Yes.
At this time, do you have any corrections or additions to make to that report?
I do. On page 1 of my report, I had mentioned that staff had discovered no violations of statutes, rules, regulations, or commission-approved tariffs. And as Mr. Pringle mentioned in his opening statement, we did receive a data request late yesterday evening from Ameren, in which they did detail that there was actually a violation based on notifications prior to the disconnection on March 4th. So I'm needing to amend my report to reflect that on page 1, as well as on page 4 and page 6.
Thank you, Ms. Fontaine. And also, when it comes to that DR, do you have a copy of what is DR 13 in front of you?
I do.
And did you have a chance to review that response?
Yes.
And based on that response, was staff aware of the situation that Ms. Kutchmar also described further during her time on the stand that happened in 2022?
It does look like our consumer services department was made aware back in March of 22 of that occurrence.
And then based on the information in that data request, does staff believe that concern was resolved?
From my understanding, yes.
But regardless, at the time of the disconnection in March 2022, staff has determined based on that DR that a violation occurred.
That's correct.
Thank you, Ms. Fontaine. And with those additions and corrections, is everything else in your report true and accurate to the best of your belief and knowledge?
Yes.
Thank you, Ms. Fontaine. Judge, at this time, staff moves to enter on the record Staff Exhibit 200C and 200P. Also, when it comes to the corrections, if you would like for us to file an amended report or an errata sheet, we will do however you would like for us to proceed.
If you can just file the latter.
All right, will do.
Thank you. Are there any objections to admitting Exhibit 200, staff's report?
No.
Okay. It is admitted.
Thank you, Judge. At this time, staff now tenders Ms. Fontaine for cross-examination.
Okay. Cross by Ameren.
Is anyone there? I think I might have lost you all.
Mr. Hernandez, can you hear us?
I'm not hearing Ms. Hernandez.
Nor am I.
Yeah. No,
Sorry.
I can't.
Using
either.
yourself? Yep, I turned mine on. Sorry, we are having a little technical. You did the wrong one. Sorry. So, but you're here. I'm gonna mute me.
Okay.
That's bad feedback.
Apologize for that. We were trying to switch from witness cameras to mine, so. Good afternoon again.
Good afternoon.
I do have a couple questions for you. Let me just pull up the DR. All right, would you agree with me on February 18th, 22, a disconnection notice was mailed to the complainants advising them that 241.26 was needed to be paid by March 2nd, 22 to avoid interruption of service?
Give me just 1 second. I'll pull up the disconnection notices. I'm sorry. Can you tell me the dates again?
Oh.
I object. The violation has already been found.
What was that objection?
The violation has already been found.
I'm gonna overrule your objection. If you could answer the question, Ms. Fontaine, whenever you're ready.
Yeah, I was just looking for some clarification or
Sorry.
a repeat of
Sure.
the dates again, if you don't mind.
Sure. My question was, would you agree with me that on February 18th of 2022, a disconnection notice was mailed to the complainants advising them that $241.26 was needed to be paid by March 2nd, 2022 to avoid interruption of service?
Yes, I do have that in front of me.
Okay. And you agree with that statement?
It does appear that I do have that disconnection notice in front of me, and it does reflect those same dates and amounts.
Okay. And then you would agree that on March 2nd, 2022, Ameren made an outbound collection call to the complainants. And our records note that there was a status of an answering machine message left.
Yes, that's the information I've been provided.
Do you have any reason to doubt that information?
No. On the account notes that I originally received in my first initial set of DRs, it did show 2 outbound calls on March 2nd. However, in the DR that I received yesterday evening, in the response from Ameren, it explained the situation and said that there was only 1 outbound call on March 2nd.
Okay. Is there a possibility you could have misunderstood the account record in terms of whether the 2 calls were made?
It's a possibility. I don't know. Each utility has different terms and such that they use. But based on what I was provided, it did appear when I initially, had those data requests submitted to me, and in that it was, it did appear that 2 calls were made.
Okay. And you would agree with me that on March 3rd, 2022, Ameren made a 24-hour disconnection call to the complainants, and that was recorded. Okay, I apologize. And that was recorded in Ameren's records as a live answer by the complainant?
Let me get there real quick. Yes.
Okay. And would you agree with me that when Ameren realized the March 2022 system issue, that Ameren was proactive and notified the commission of the issue versus, not the commission, notified staff of the issue versus staff realizing something occurred and then talking to Ameren, Missouri about it?
From my understanding, the conversations were had between our consumer services department and Ameren. So I can't say exactly what communications occurred and when. However, it does appear that communications were had between those 2 parties.
Okay. Would you agree with me that Ameren was transparent to the staff about what had occurred?
It appears that way based on the information that I have.
And then, I guess just for clarification, I want to make sure I understand your response. You would agree with me that Ameren reached out to staff to notify them of the issue, of the March 2022 issue?
Based on the information that Ameren's provided to me, they did reach out to staff. However, I was not the staff person that they reached out to, so I can't I can't say 100% that was how it occurred.
But you have no reason to doubt that information.
No, I don't have any reason to doubt that.
Okay. Just one moment, I'll check and see if I have any other questions. No further questions, thank you.
Thank you. Crossed by the complainants.
Okay, thank you. Sarah, if you could, or Ms. Fontaine, if you wouldn't mind, could you please state what your position is one more time? I just want to make sure that we're all aware of your professionalism.
Sure, I'm a senior research and data analyst.
Thank you, thank you. So would you agree with me that you are quite capable of understanding any of the documentation that you are set to investigate?
I would agree.
Okay. All right. With that being said, could you look over those records one more time in reference to the March 22 shutoff and see if there was a payment, even if it was 10 cents made before the shutoff and again, a payment made the day of the shutoff and after?
Okay, let's see here. So looks like from what I have in front of me, there was a payment made on March 7th, 2022 for $194.77. There was also a payment agreement that was reinstated for $13 per month for 10 months.
Okay, and that was done the day of the disconnect, correct?
March 4th, yes. That was the date that the payment agreement was reinstated. It looks like the payment actually went through on March 7th.
Okay, thank you. I wanted to make sure that that was clarified, the day that we actually did do that. And then after that payment, the following payment for I believe the month of April, was that paid as well?
It looks like there was a payment of $93.94 that went through on April 20th, 2022.
Okay, and was there a remaining balance rolling over from that besides the $13 payment agreement amount?
From what I'm looking at, it looks like there was a zero balance after that payment on April 20th of $93.94.
Okay, that's all the questions I have, Your Honor.
Okay.
Thank you.
Are there any questions from the commission?
Not at this time,
Okay.
Judge. This is Commissioner Kochmeyer.
Commissioner Kochmeyer has joined us as well. I have no questions either. If staff would like to redirect.
No redirect, Judge.
Okay.
Just ask that Ms. Fontaine be excused.
You may be excused, Ms. Fontaine.
Your Honor, I did have
Yes.
one redirect question, if that was okay.
It would be considered cross, but sure.
Okay, I apologize.
That's okay.
Ms. Fontaine, one last question for you. And what you're seeing, were we included on those calls that came in on March 8th when it came down to the error that was made? Did we receive any outreach from Ameren in reference to that, or were we not included in that due to the payment being made?
I don't see any telephone calls based on my records. And my understanding was that you wouldn't have been contacted since you had been reconnected at that point in time.
Okay, thank you. That's it.
Okay. Ms. Fontaine, you may be excused. I think I'm going to briefly recall Ms. Canada because we did get a lot of, more than 50 exhibits that you could offer. I'm likely not going to have those, especially the MP3s. I don't think we're going to play those now. I think they're still going to be considered late filed to give council the opportunity to object since we did receive those during the pendency of the hearing, and not prior to it. If you could describe them for us so that we can kind of have an idea of what they are. I know there's a lot of MP3s, some PDFs. Some of them are labeled, which is helpful, so that we know if I assume that you're wanting to offer each of these, which maybe is a first question. I saw some are zip files and things too, so I know that there's a lot of things there, and that's fine. It would still probably be considered one exhibit as a zip file. It's just easier to do it that way. Can you explain what the relevance is of some of these MP3s? I'm not sure how many there are. I see 30 labeled that way, roundabout, and then some PDFs in there as well, so I'm not sure the exact number of MP3s.
Right. I can summarize most of it if you want to just review it because of the tardiness of the information. And I'm glad that some of it at least came through because I was freaking out a little bit about that. But to summarize the evidence that you're seeing in front of you, these are bills from, or excuse me, either email communications from United Healthcare of the day of the completion of payment, the initiation of payment. There are some that are actually the web link from United Healthcare where it shows what bill is being paid as far as, let's say, there's one that says $75 for Ameren. I believe that was for August. I'm not sure if that's in, because I don't have them in front of me with Dranel gone. I can't pull it up. I can't see to do it, but I'm trying to summarize what you have there. Several of the submitted information is simply communications from Ameren that they sent us via email, via text message, saying that they did receive these payments, showing the credited amount that was left over from these payments, so on and so forth. And then the recordings that you were discussing are, I'm pretty sure, some of the same recordings that Ms. Aubrey spoke on when she said the 40 recordings. So I'm sorry, with my limited vision, I can't even try to pretend that I could pull up this information to view it with you. But that is what it boils down to. I wanted to make sure that you had complete documentation. And there were, I believe, 3 activity statements that we were sent during the course of this whole process. And if you notice, some of them reflect differently between the 3. It's just a lot of information that either kind of proves that what we were stating throughout this hearing has been true to the best of our knowledge, or as communications from Ameren themselves to us, confirming that the statements that we have made have been true during this hearing. So I just put together everything that I could find in reference to this this hearing, and that is how many it came out to be. So I hope that kind of gives you a better idea of what you're looking at there. If there's anything in particular that you might want to ask me about, I can try my best to answer the question based just off of memory as well, but I can't pull it up. I'm sorry.
No, that's okay. I think generally that's fine. And just to clarify, the communication was either you or Mr. Clark were involved in these communications?
Yes.
Either recipient or a party if it was a phone call.
Yes.
Okay. And then there are also some documents that were sent separately before the larger portion that was still probably around 30 documents that we'll get into that. Actually, I want to release the commissioners. I don't think you guys need to stay on for this portion. We'll just be kind of clarifying exhibit numbers and things and what's being offered and entered. So I apologize for not letting you go now at this stage. But so,
You excused the commissioners, did I understand that, Judge?
yes, Commissioner Kolkmeyer,
Okay.
yes.
Thank you, Judge.
And I thank you for your time, sir.
Yes, absolutely.
Okay. And so I think generally with these, I would probably stick with the numbers that we have for
Okay.
the larger email that we got. There's like 34 that are already labeled as those numbers. I think that's fine to leave those. I think there's 49 total exhibits in that email, and that is including some zip files, which I think we can count collectively as an exhibit. Then there were several others in that other email that that Mr. Pringle sent to us. And if we want to label those, we can probably keep them as they are, just those 4, making it 53. Is there any objection to just calling those 53 exhibits?
That's fine with me.
For labeling purposes?
Yes.
Mr. Pringle or Ms. Hernandez, are you guys okay with that?
No objection from staff, Judge. Thank you.
Okay.
No, I got it. Judge, I'm sorry. I was looking at the exhibits. I'm trying to understand, how are we numbering them?
So I
Or which
figured
one?
we would leave, there's one that was sent at 239 that has 34 that are actually labeled as that number. I figure we just count those as 49, 1 through 49. And then there's another 4 that were sent at 204 from Mr. Pringle, and I figure we would just say 50, 51, 52, 53. If we could do that in order.
Understand now.
Does that make sense?
Yes.
Okay.
And Judge, we just wanted to make sure that you knew that the ones that you're speaking of right now, the 1 through 43 you were just mentioning, those are the ones that are coming from the flash drive. They're included in that as well.
Okay. I appreciate that. And I'll consider those late filed so that Mr. Hernandez and Mr. Pringle have the time to review them and file objections if they'd like. I don't expect any more exhibits. If there are any, let me know. I don't really want to keep that open. I'd rather just have objections available by Friday is what I would prefer to hopefully get this all squared away this week. Is that okay with the parties?
You're referring to this Friday,
Yes.
Judge? Okay.
Could you repeat that one more time, Judge? I want to make sure I understand what you're saying.
So rather than have, are there any more exhibits that anyone intends to file?
The only ones that I have that need to be filed includes the bill that I've made mention of, or not the bill, but the website view from Ameren. When I mentioned the June 22nd through July 6th, I have that in this information that I'm having a hard time getting over to you all.
So that has
It
not,
wasn't included.
I don't mean to
No,
cut you off, that has not been sent yet?
No, sir, it
Okay.
hasn't. And that's what I'm really trying to get so that Aubrey can see exactly what I'm talking about as well. But that is one of the most important ones that's included in the one I'm trying to get to you. And I want to say that we counted those out to be 32, just either screenshots or picture filings of some kind.
Okay, so why don't how about I leave it open until Friday? And then give the parties, so the 24th is when I would have the remaining exhibits due. And then I'd like to have objections in by the 30th.
Okay. And then when would we be reconvening?
It would depend on if staff or Ameren requires that to cross-examine or otherwise. I don't know that there was anything needing to be cross-examined. It seemed like it was all just exhibits and recording, so I don't know that we would need to. But I didn't look super deeply into that. So we'll just play that by ear, I think, for now.
Sounds good. Sounds good.
And then the commission will ultimately make a ruling. Ms. Blesky, when are the transcripts due for today?
Okay. I don't believe they have a date that they've requested them. Usually turnaround is 8 to 10 business days.
Okay.
So that would put, and then, yeah, we're off on Monday. So that'd put us at like the 31st or the 3rd.
Okay. So
Okay.
around then. Okay. So we can expect them probably by the 3rd.
At the latest, yes.
I appreciate that. And I think briefs are optional, so if the parties would like to file one, then we have a deadline of the 10th to file those, June 10th. Ms. Candida, all that would be is you kind of going back through your petition or your complaint and things in written form. Most pro se parties don't do them, in my knowledge, but it is an option for you. Usually a deadline is kind of when parties do tend to file them. So I'm not going to guide you one way or the other. You can do it if you'd like. I don't know that you'll have necessarily much guidance in our case, because I would expect them to be filed closer to that deadline if you do intend to file it.
That was June 10th, you said?
June 10th, yes. And I think that was in our
Yeah, the original.
the schedule.
Yes.
Okay. Are there any other matters that need to be addressed before we adjourn?
Just quickly, Judge.
Yes.
Oh, sorry, Jennifer, you can go.
Oh, thank you. I didn't mean to cut you off. I just wanted to double check, Judge, while we're still on the record, to make sure all the exhibits I wanted to be admitted were admitted. So that would be 100C, 101C, 102C, 103C, 105C, and 106 public.
Yes, each of those were admitted.
Okay, thank you.
And that was, one more time, that was 100 through 100 and what was the last number?
So it was 100. I can go through it. 100C, 101C, 102C, 103C, 105C, and 106 public. Meaning that it's not got confidential information in it.
Okay.
Yeah.
Okay.
So 104 was not, it was not offered or admitted. And was that your question too, Mr. Pringle? To confirm?
My big thing was about the exhibits that have been sent in by the complainants. I guess will the data center be handling?
I'll get them to him.
Okay, and then if I know Ms. Canada brought up the idea of 32 other ones. If they come to me, should I just send them on to the data center and include yourself and Ms. Hernandez on that email?
Yes, I would appreciate that.
All right.
I would appreciate that too, because it seems like sending it to Travis is the only way that it's been going through. So if that's okay with you guys, that's wonderful. Wonderful news.
I do want to clarify too. It could be that the size is so big. As I mentioned, there were some zip files, and with audio recordings and video recordings and things of that nature, they're oftentimes larger. The data in them, even something that I learned in practice is whenever we had to do redactions and things, at least more commonly, that also, if there's anything you add to a PDF, that can also make it adds data. So that could be part of the issue is the data size. And I think someone mentioned too, it could be from the number of recipients even. But I know that I think Outlook has a limit on how much it can receive, so that may have been part of the issue.
Okay, I'll make sure to mention that. I'm glad you said that. Thank you. Thank you.
Sure.
So just try to break it up a little bit better. Is that what you guys are saying? Just try to separate them a little bit and see if that works then?
Yeah. Yes.
Okay. Okay.
Yeah, because I'll echo that, Judge. The last email that I forwarded to the parties, that one did take about 5 minutes to get out of my inbox.
Oh, wow.
Yeah, but we appreciate it regardless. We appreciate that you were able to send it over to us, and I think today went really well. I want to thank everyone for their patience and, working with each other and being respectful in things. It's a good time. So, ultimately, as I mentioned, or as Ms. Gillespie mentioned, the transcript should be hopefully available early June. And then we will have our order shortly thereafter. And with that, I think we can adjourn and we can get off the record.
All right. Thank you all for your time. I appreciate it.
Thank you. Have a good day.